court was mistaken by referring to quorum instead of composition. But if you had read further, what we want to do is to read further than that. So it says the respondent's submission that the JSC would not have a quorum in order to take valid decisions if Dr. Kloppe is interdicted from participating in that forum is incorrect. In acting the Premier's case, the court pointed out that the majority support for decisions required by Section 178.6 is the majority of members entitled to be present according to Section 178. In that case, the issue was whether the Premier's attendance was necessary. The court concluded that it was bearing in mind 178(1)K of the Constitution. In this case, the absence of Dr. Kloppe and on the JSC would not be significant. There would still be...
Kloppe was quite emphatic on this.
Yes, but he didn't read the last sentence, my lord.
Yeah.
There would still be 5 NA members represented on the JSC, constituting a majority of such members. They are making a different point, that if the court impugned the designation of the 5 members, it wouldn't be making the statement at paragraph 56.
Oh, I see.
Yes. It didn't impugn that because, my lord, the court's reasoning must be read to its logical conclusion. When the court says, in the context of Dr. Kloppe, the National Assembly failed to exercise, to appreciate that it had a discretion and to exercise it. It's because, in his case, if the discretion was exercised, they would have taken into account that he had been removed as a judge, and you will find that in the reasons. But you wouldn't reach that conclusion with the other 5 members. So it's not simply to read half bits of the judgments and say that they're saying they're impugning the entire the way in which the JSC exercised this discretion and did not stop at only Dr. Kloppe.
I mean, to be fair, Mr. Kloppe didn't really concentrate a great deal in the argument on that.
Yes.
What he was saying was that the same reason as was found by the Supreme Court of Appeal in the Cape Bar Council and the Premier of the Western Cape,
yes,
non-attendance by Dr. Kloppe in this instance means that the JSC is improperly constituted.
Yes, I'm coming to that.
Yeah.
Yes,
That seems to be the main point.
That was the main point.
I understand what you're getting at.
Yes.
But, insofar as the rationality of the decision is your part, it seems to me that that's the first of the 2 critical points you have to make.
Yes. I mentioned that point because the reason they say the JSC's decision is irrational is first for the reason I've already addressed about the binding effect of the judgment, but they also say the composition would be unconstitutional. I'm coming to that now. But Mr. Ngalwana, representing Dr. Kloppe, added the point that,
yes,
in fact, there are far more. There is an issue the JSC ignored, which is that the High Court judgment impugns the designation, including of the 5 other members. And I took advantage of, because I was at that paragraph, just to highlight that point, that in fact, in that submission is inconsistent with the content of the judgment itself and how it hangs together in reasoning why there were sufficient prospects of success in the review of Dr. Kloppe's designation. It's because the failure to exercise a discretion ignored a relevant factor, which is that he was removed by the same body, which doesn't apply to the others.
Yes, but I think Mr. Ngalwana clarified that his submissions in that respect really went to the bounds of convenience. I'm not sure he was suggesting that the JSC was irrational because it had taken the wrong view of the full court's decision on that. I'm indebted to my Lord to clarify that, because then in respect of balance of convenience, I essentially put him, I put it in these words, but first of all you've got to look at the order.
Yes.
The order doesn't say anything about the upper. And secondly, if there are passages of this judgment that might be read in that way, they are passages that lead to an interlocutory.
Yes.
Final definitive findings of the fitness or the lawfulness of the appointment of the other trial.
Yes.
And that's when I think Mr. Ngolwane said, well,
it goes to balance of
yes,
convenience.
Convenience, really.
Yes.
It's not about rationality.
I appreciate that, my Lord, that clarification. The submission I would make is when we get to balance of convenience, that doesn't get into the port because it doesn't get anywhere.
You may well have your submissions to make.
Yes. Just going into the Constitution then, we start that, my Lord, at paragraph 52 of our heads.
Yeah.
And we start off by setting out section 178 and making a couple of submissions related to that. Paragraph 54 is simply to say that subsection 3 provides that members of the Commission, other than those designated by the NCOP, serve until they are replaced by those who designated or nominated them. Then we refer to decisions and how decisions are made. And 178, it's where certain designated members may not be able to attend, and there's provision for alternates. And under 57, we make the point that the clear import of section 178(1) of the Constitution is that once persons meeting the criteria of subsections A to K have been designated in the manner and by the person or entity prescribed, the JSC becomes properly constituted. So the Constitution and presence at a meeting are two different concepts.
Yeah.
We make the point. And then we refer to the 50-50 police split, which is 178(1)H. And 59 is the effect of the Western Cape High Court order, which is simply only that he's prohibited from participating, he remains a member, and so the High Court order has not affected or altered the split, which is a composition issue, the 50-50 split. It's an issue of attendance, whether you will maintain the 50-50 split, and I'll come to the attendance issue.
Yeah.
And while the courts in 62, while the courts have acknowledged that the list of office bearers composing of the JSC is carefully structured, the cases confirm that the absence of a JSC member does not, without more, invalidate the proceedings or the JSC or its decisions. And that's where we tend to the relevant judgments, because they make it very clear that it is only when the absence lacks proper justification that there might be a nullification of JSC proceedings and decisions. But where there's proper justification, there isn't. And that's a ratio, that's the reason of principle, that all of the judgments that our learned friends referred to are discussed in the Thorpe case, which is a case involving the first applicant and the second applicant. The full court decision in this decision, which is binding on this court. We summarize at 63 that Dr. Thorpe had relied on the Skirhold principle that if a statute prescribes specific office bearers to attend meetings and does not prescribe a quorum, it's assumed that all of them must attend, and that otherwise the proceedings where not all attend would be a nullity, and the decisions made would be a nullity. My Lord, the judgment of the full court dealt at length with the implications of all of the SCA judgments that our learned friends have said to my Lord, they bind the court. And my Lord will see at paragraph 30, from paragraph 38 of that judgment, of the full court judgment. It follows on a discussion of the Skirhold principle and says at 38, the SCA, however, in JSC versus Cape Bar, considered itself bound by its judgment in Premier SCA, saying that it follows that if the JSC cannot take a valid decision in the absence of either the Premier or her alternate, the position can be no different with regard to the absence of both the President of this court and his deputy. However, like in Premier, the SCA held that it was because of the lack of justification for the absence of the President of the SCA and his deputy that the JSC was not properly constituted at its meeting and that its decisions at that meeting were therefore invalid. What emerges then from this case is the inference that proceedings will not be regarded as a nullity if there are justifiable reasons for an absence or exclusion of a member entitled to sit. The justification qualification was crucial to the findings in respect of composition. Therefore, it would be a mischaracterization of those cases to say that they are analogous to the present matter or that they provide authority for the proposition advanced on behalf of Klope JP in the present case. It would be a mischaracterization of those cases to say that they dictate that generally, in the absence of the President and Deputy President of the SCA, the proceedings of and decisions taken by the JSC were invalid. Those cases tend on the absence of a justification for non-compliance with the composition requirements. They are therefore, as was submitted on behalf of the JSC, wholly distinguishable from the case with which we are seized. And why? Because in this case we are furnished with reasonable and adequate justifications for the absences of Maya and Petsy DP. The justifications of Maya P and Petsy DP were uncontested. Both judges explained their absence on account of their personal relationships with Klope JP, so it's a conflict issue. On the basis of the above cases, then, their justified absence do not render the proceedings a nullity. There were valid reasons for their non-attendance. They were not unjustifiably excluded, nor were they unjustifiably absent. In the light of this, there was a reasonable justification of their replacement. My Lord can read further. And here, there is justification. The justification for his exclusion is the binding court order of the Western Cape. Our learned friends can quarrel with that judgment. What they have failed to do is to get its operation suspended so that it doesn't provide justification for his absence from JSC proceedings. The argument of our learned friend, Mr. Ngalwana, starting off under interim interdict with what is the right. He says he's got a right to participate in JSC proceedings. My learned friend, Mr. Mpofu, says that's a political right he's got to represent, take part in the activities of MKP. Yes, true. But why can he not exercise those rights now? Because there is an interdict, which in terms of Section 1 of the Constitution, read with Section 2 and 165(5) of the Constitution, is binding on the JSC and on Dr. Klope. He can't go there and attend without being in contempt of court. And that is the reason why he's not there. Our learned friend says somehow it is the JSC that is depriving him of the opportunity to participate, because if it postponed, well, they can't say if it postponed the proceedings, he would participate. All they can say is if he postpones the proceedings, there might be clarification whether he should or shouldn't participate, because one can't proceed on the assumption that he's going to succeed in his appeal against the interim court order of the Western Cape High Court, or indeed in Part B, they might find against him. So he might never return to the JSC, ultimately. So one can't approach the argument on the basis that if the JSC postpones, Dr. Klope is going to participate. No. If the JSC postpones, Dr. Klope will vindicate the case he has against the parties that went to court, whether he should be in the proceedings or not. And the only debate, the real debate, is should the court restrain the fulfillment of an important constitutional function to wait for Dr. Klope to vindicate his rights, which he has so many avenues to vindicate. He could have suspended the operation of the judgment. He can expedite the proceedings. And because the JSC proceedings are not invalid by reason of his absence, no constitutional provision is breached if the JSC in the meantime carries on and expedites proceedings to clarify his position. There is no reason to jeopardize the functioning of the courts, of the judiciary, and the proper administration of justice, just so that in the unlikely event that the court had him in Part B and in his appeal, he might succeed. He might succeed, my Lord. He may not succeed. So with respect, all three reasons that the JSC offered are not only rational, they are correct, my Lord. And there is no basis for this court to find that the JSC acted unconstitutionally as the declaratory relief seeks the court to do. And I've addressed the fourth basis, which was dumped into the balance of convenience category, that too doesn't assist. So when our learned friends say, but the court must look at the constitutional impacts of not having Dr. Thorpe on the JSC, that is an argument that they have made and they failed on before the Western Cape High Court, because the Western Cape High Court would have been met with an argument that Dr. Thorpe has political rights, he must carry out a constitutional duty on the JSC, you cannot interdict it. When you do that, you're upsetting the whole constitutional arrangement, including the 50-50 split. The High Court said, the 5 will be there. That's sufficient. The majority will be there. That's sufficient. That finding and that judgment is binding on the JSC, is binding on the applicants, is binding on this court, because it hasn't been suspended. And it will only be set aside on appeal. And the courts have made it very clear that the fact that a judgment may be set aside on appeal doesn't mean in the meantime, unless suspended by a court under Section 18.3, is not binding, continues to bind. The ratio continues to bind. So with respect, we submit that there is no case for the declarator. The real point why you have a declarator put up like that is that MKP is quite aware that it would face a difficult hurdle to clear the outer test for interim relief. That's why it wants the court, in a sense, to read into Section 172B of the Constitution and Section 38 to allow for a court to grant an interim interdict in the air without meeting the 4 requirements for interim interdict, which have been clarified by the Constitutional Court as being constitutionally compliant, and there's no need to fashion a new test. And when I come to interim relief, which is what I will tend to, it is that test which must be complied with, and we submit that is not met at all. My Lord, if I can tell...
On that point, if an organ of state takes a palpably irrational decision, must the court still consider some variant of the outer test or the outer test before it says so and grants appropriately? It just seems to me that the submission that you just made is either not correct or has its limits.
Yes.
It's one thing to say, well, if a party before court has a good chance of succeeding in an application for final relief, and the respondent is the state, and the state has special duties, one has to take account of the impact of restraining the state from fulfilling those duties pendente nisi. And that is separation of powers. It's usually located with the balance of convenience like at the stage, like the test.
Yes.
But it is, I think, conceptually distinct, isn't it, to say, well, actually, what we want you to decide is not anything on an interim basis. What we want you to declare is that here and now, this decision was irrational. And because it's irrational, can have no force or effect. Those are two distinct arguments, aren't they?
Yes. So we would submit that if the court finds that the JSC decision is rational, there's no scope for interim interdict being granted.
Yeah.
Because you would never have you can't demonstrate a right that's been breached. There's no right to a postponement. There's only a right to a rational decision, a proper consideration of your request for postponement, and a rational decision. So once the...
Well, if I were to decide that the JSC's decision is
Irrational.
Irrational.
Yes.
Irrational. Emphasise our syllables, shouldn't we? Then it follows from that I must conclude that the decision was taken in breach of Section 1C of the Constitution.
Yes.
It follows from that I have just and equitable power to determine an appropriate remedy under Section 172.
Accept that.
Yeah. That's a completely different railroad from on contour with Cizwell, Dr. Flaucret's rights have been breached prima facie by the JSC's decision. They may or may not in due course get a declaration, have a court conclude that finally and definitively that those rights have been breached.
Yes, I think...
And for that reason I apply the interim interdict test, which includes outer, because the JSC is not in state.
Yes.
Those are two manifestly different propositions.
Yes, they are. The only point is when the court considers just an equitable remedy and following upon a declaration that the JSC decision was irrational, the factors that we raise under balance of convenience are still relevant in that they speak to the public interest, because that just an equitable remedy, under just an equitable remedy, the case law is quite clear that public interest is paramount. So you would still consider whether it is a case in which, just because a declaration of invalidity has been issued, there must be a consequence that the proceedings mustn't take place. They are either postponed or interdicted. So it's not an outer structure, but the facts that are referred to in the assessment of interim relief, especially in relation to balance of convenience and harm.
It's conceivable that a court could say, well, I don't think the JSC was rational in this particular instance.
Yes.
But here is a rational basis on which they should proceed.
Right.
Well, there's no reasonable basis on which they shouldn't proceed.
Yeah.
Therefore, it's just an equitable that they proceed.
Yeah.
That's conceivable. I'm not saying that's what the facts of this case say.
Yeah.
Not even saying that I would even get that far. But I could just leave it at a declaration, couldn't I?
Yes. So it's quite. It's conceivable that the court might say, of the three reasons the JSC gave, one or two are not rational, and in its view they are the predominant reasons, and therefore they render. I think that's the approach that the SCA adopted in Westinghouse, where they said there was a dominant reason is in a tender context. The reason you have applied is a reason that was not stipulated in the tender evaluation criteria. Therefore, that's an impermissible reason and is the predominant reason, and it renders the decision irrational. So if, on the other hand, assuming the court were to find that the JSC was correct, that the judgment is binding, the JSC was correct that the proceeding with the meeting on Monday is not unlawful because of what the full bench says, but there's some other reason for which it would have been in the interest of justice, or a factor that the JSC didn't consider should have been considered, and the court takes the view that that renders the decision irrational and can warrant a declaration of irrationality, of invalidity. It doesn't follow that there must be a postponement and or an interdict. Yes, but I'm very indebted to the court for drawing, for splitting the routes, as it were, to the outcome. But one can wish away what has been pleaded. Yes. I've got 5 minutes left.
Yeah. By my count, two.
My learned friend said I can borrow another 5. Another 5 from them.
You're in a position to round off.
Yes.
Then that's fine. Thank you.
On the requirements for interim relief, my Lord will find our heads from paragraph 97. We've set out 4 reasons why he doesn't have a right, Dr. Flope. First, he doesn't have a right to attend the proceedings because of the interdict, which is in place. Secondly, there's no right to a postponement. He was entitled to a rational consideration. That's what he received. And the court has already found that there are sufficient prospects of success in the review of his designation that would annul his right to participate, so to speak, because that's what the court found. And the fourth is the the appeal right doesn't require an interdict, my lord. There's a special remedy in section 18.3 and 18.2 if you want to protect that. And on balance of convenience, we've said much of what we need to say. It's all in the affidavits. It's really his interests versus the public interest here. And also, where the right is not strongly established, balance of convenience would have a much more pronounced consequence. And on irreparable harm, we've highlighted the case in City of Tshwane, which says that one of the crucial elements that must be established before an interim interdict can be granted. And that irreparable harm is the irreparable harm linked to the relief that you seek, and is your irreparable harm. In this case, he's talking about irreparable harm to the Constitution, to the JSC, to the public interest, but it must be harm that one can link to him and is irreparable. And we've submitted that is reparable, because if he succeeds in his appeal or in Part B, he comes back. In the meantime, the proceedings go on because they can do so lawfully under the full court judgment of this division. Alternative remedy, we've mentioned all the alternative remedies that he has. The Section 18.3 remedy for him to attend, because there's no point in postponing. The whole point here is about him attending and participating. Is the Part B and the appeal, which can be expedited. And at the end of our heads, from paragraph 109, we have a section dealing with dire consequences for postponing the JSC's October sitting, and that is all about the administration of justice, my lord. That is a factor that applies to the balance of convenience.
Yes.
My lord, we submit that on all of what we've submitted in the affidavit, in the heads, bearing in mind this is urgent court, this application should be dismissed. We don't seek a cost order. We simply ask the application be dismissed.
Thank you.
As the court pleases.
Lord, I'm not going to deal with the issues in the same way as my learned friend looking at the prayers. I intend to address them in the following order. First, I want to make a few remarks about the nature of the challenge that's before this court. Then I'm going to deal with the designation of the 5 other MPs, other than Dr. Klopper. Then I'm going to deal with the presence of Dr. Klopper at the JSC. And those are the 2 main grounds on which this relief is founded. Then I'm going to deal with section 18.2, and Finality with matters or not. I'll then deal very briefly with the interim time. We'll have covered most of the ground, I think, for that with your remarks. And then finally, I have a few things to say about remedy, the relationship between section 172, 1A and B. The first point is that prayer 2 of this application is a review. It's framed as a declarative. But what it really is a review of the postponement decision. Because if this court were minded to grant that declarative, that would trigger not only its power, but its obligation under Section 172(1)B to consider what other just and equitable relief to grant, which may include a reviewing and setting aside, or may include some other relief. But that's exactly what happens in a review, is the court decides whether the decision is lawful or unlawful, and then decides whether to set it aside or not, whether to suspend it, whether to grant other relief. It's a review, final in effect. That much has been said repeatedly. But what is it a review of? It's not a review of a final substantive decision by the JSC to appoint or not appoint certain judges. It's a review of a step in the process, a decision to have a meeting. So it's a review of a decision in medias res. And there's direct precedent for this issue, which is the case of the Public Protector of South Africa versus Chairperson Section 1941 Committee. The citation is 2023 ZAW CHC 73. And that was a case in which the former Public Protector, Advocate Mqobane...
Can you that reference again?
2023 ZAW CHC 73. That's the Sapley reference, my lord.
2023 ZAWCHC
73.
73.
So it was a decision of a full bench of the Western Cape High Court. And what happened is Advocate Mqobane, during her Section 194 impeachment proceedings, brought an application challenging various decisions that have been made, to refuse postponements, to not recuse themselves, various decisions that the chairperson and another member of the committee have made, and including a decision not to grant a postponement at a certain point. And what the court said is that when you're challenging, this was in the context of Parliament, but we submit the same applies to the JSC, is that ordinarily courts will not entertain reviews of decisions in medias res. What you're required to do is wait for the final outcome, and then you can review that decision. And there's good reasons, because otherwise organs of state, like Parliament, like the JSC, are hamstrung, are unable to do their duty. So it's only where there's grave injustice or irremediable harm that cannot be remediated by review in due course that a court will even entertain reviews in medias res. But the other reason I mentioned this is it's important to think what the JSC had to decide here is, should it proceed with a hearing where it is going to interview candidates and make decisions or recommendations to the President about who should or should not be appointed. And what I had to decide is, well, is there a risk that if we go ahead with this hearing, that our decisions that we make will be compromised in some way and may be liable to be set aside? And I had to take whatever risk it thought might exist and weigh that against the cost of granting the postponement. And the cost has been set out in detail, and it's obvious. There's a cost to the administration of justice because judges will not be appointed, and there's fruitless and wasteful expenditure of 3 million rand at least. So those are the obvious costs, and that's what the JSC was doing. And so it's weighing that risk. And the question for this court is the way it weighed the risk irrational? Was it irrational for it to say, well, I don't think there's much risk that these decisions, any decisions we might take, might be set aside. The cost of postponement is massive, so I'm going to refuse the postponement. Was that rational? It was obviously rational. And I'll get to why the risk is, if there's any risk, is incredibly low in this case. And so what the JSC, the decision it took was, as Mr. Mainesha said, not only rational but correct. So that brings me to the first sort of substantive basis, which is the position of these 5 other members of Parliament, the remaining delegation of designees. And before I get there, I think it's important just to clear up some lingo. The difference between composition, attendance, and quorum. And I think this is usefully set out in the JSC's heads. But we disagree slightly with what they say. That the composition is, have these people been designated, the people listed in 178.1. And there's no dispute that they've been designated. Everybody, including Dr. Klopper. The next question is, who needs to attend of those people have been designated in order for the JSC to act lawfully? So I'll get to the case law later, but we submit that what the position is all the designated people must be invited, they must know about the meeting, and they must either be present or there must be a justified reason for their absence. And if those conditions are met, the JSC can go ahead and take lawful decisions. The word quorum is somewhat misleading in the case of the JSC, because nowhere does it set what we traditionally call a quorum, where it says X percentage of members must be present. What it says is a decision must be taken by a majority of members. So any decision must be a majority of the members, not members present, members of everybody of which the JSC is composed. So if 2-3 members are absent because they're sick or a court interdicted them from attending or for whatever reason, they still need a majority of the members in order to take a decision, not a majority of members present. But that's not a quorum issue. That's a how many votes do you need to take a decision issue. And sometimes these issues get confused, that they use it somewhat interchangeably. But if one looks at the full court judgment, it's very clear that what they're really concerned about is attendance. It's not composition. It's not quorum, which isn't really an issue at all. It's attendance. So, turning to the question of these 5 designees, we say there's 6 reasons why the JSC was correct to conclude, 1, there's no risk, but even if there is a risk, it's a minuscule risk. The first reason is that only Dr. Klopper was before the High Court. The DA, Full Corruption Watch, only challenged Dr. Klopper's decision. And Mr. Mainesha took you to the paragraph where the Full Court expressly says it's not affecting the position of the other 5. It says they will attend. So that was clearly the position. The second reason is that their designations are valid until set aside. Odekrol, Kurland, basic public law principle. And in this case, not only have they not been set aside, they haven't even been challenged. It's a very peculiar feature of this case that the Part BB review is framed as a review of the postponement decision, not a review of the designation of the 5 members, which is then put up as the reason why the postponement was bad. Nobody has challenged it. MK, Dr. Clawback, haven't even said that they intend to challenge it. And there's probably a good reason for that, because their position in front of the full court was that the mistake of law rubber stamping review ground was bad. And so if they were to challenge it, they'd be advancing an argument directly contradictory to the one they used to defend Dr. Kloppe's designation in the challenges brought by the 3 applicants. The third reason is that whatever the full court might have said is not final. It's prima facie. It's very clear that its findings are prima facie findings. And we know that particularly because it refused expressly to grant final relief that was sought before it. Freedom under law didn't seek interim relief. It asked for final relief on these same grounds. The DA called it mistake of law, Phil called it rubber stamping, but the same ground. And Mr. Trengove, who was then arguing for freedom under law, argued vociferously to the, well, maybe that's wrong, argued persuasively, cogently. Trenchantly, that's the correct word.
Yeah,
Trenchantly.
trenchantly.
I wouldn't say cogently, because
That is the kind of word I would associate with Mr. Trengove.
trenchantly, that the court had no choice but to either grant or dismiss that relief. And the full court took a different view. It took the view that it wasn't obliged to decide it and did not decide it. So we know it was only prima facie. Yes, some of the language is strong. We see that in interim interdict cases all the time.
Yeah.
Judges maybe express themselves trenchantly. But as a matter of law, what was decided is there is a prima facie right and nothing more. The fourth reason is that there is a substantive difference between Dr. Klope on the one hand and the 5 other designees on the other. And the important issue is when these nominations were made, the 6 nominations, there was no objection by any political party to those 5. The only objection was the objection raised by my client, the DA, and it was only raised with respect to Dr. Klope. And if you look at the debate, the Hansard, the debate was only about Dr. Klope. So, in substance, there was agreement. Not only was there which was the position for Dr. Klope, well, we may not like him, but there's nothing we can do about it. For the other 5 groups, no, we like them, we think they're great. Let's send them to the JSC. So whether the same ground of review that may or may not in due course succeed against Dr. Klope will succeed against the 5 others seems very doubtful. They're very different cases. And because no one's reviewed them, we don't know the record, we don't know much about them. I mean, there's a further point that even if a court found that there was some technical irregularity in the designation of those 5 people, what remedy is it going to grant in those circumstances? Is it going to set them aside with retrospective effect? Or is it going to say, look, I'm going to grant your review, suspend the order, and then go and fix it, because everybody was happy with these, but go apply your discretion you now know you have, and let's move on and avoid any disruption. It seems quite likely that's going to be the outcome. Which leads me to the 5th point, which, if there is a review, we've got to consider the remedy, and what is there a review of? So there might be a review of the designation, there might be a review of the decisions taken by the JSC, and the decisions of the President to appoint. But even at that point, we know from the Cape Bar decision, for example, that even if you say the proceedings of the JSC were unlawful, that doesn't mean that the appointments of the judges that followed was unlawful. Because in that case, there was a review of a decision with regard to the Western Cape High Court, at which certain judges were not appointed and Judge Heney was appointed. And the court said, yes, we're declaring this meeting invalid. Judge Heney's appointment remains valid because nobody's asked to set aside his appointment. And so what would have to happen for there to be any actual risk? Because the risk we're talking about here, if we're going to be honest about it, the risk is down the line, judges who are appointed might have their appointments set aside. And that risk is so minute, because even if you get to that point, you have to review not only the meeting, you have to review the appointment decision. And what court is going to actually set aside the appointment of a judge because of this kind of technicality, the risk is, I would say, close to zero. The sixth reason, my lord, is that this isn't raised in the letter that MK writes to the JSC. The issues that are raised in the letter are Dr. Klope needs to be able to participate, and if he's not there, the proceedings will be invalid. And then, as Mr. Mainecha pointed out, there's a vague indication that the 18.2 may or may not suspend the proceedings, we're not sure. Suspend the order, we're not sure. This point is not made in the letter. So it's not something that the JSC did or could have directly considered. And maybe there's a good reason it wasn't made, because it's not a very good point. My lord, I finished this section. I see it's 1 o'clock. I don't know if the court wishes to take a lunch adjournment.
Would you like to carry on until 1:15 and then have another quarter of an hour at 2 o'clock?
I'm in the court's hands. I'm happy
to get back a tiny bit of time we've
Yes.
lost.
We
Carry
can
on
just-
until 1:15.
I might finish by 20 past. Okay, let's see how
Well,
it
let's
goes.
see where we are at
Yes.
1:15.
So the second issue is the participation of Justice Klope. So the argument here by the applicants is that if Justice Klope is not on the JSC on Monday, then the JSC will be acting unlawfully, and anything it does will be unlawful. And so you should postpone until he can participate. It's very interesting, as Mr. Mainecha again pointed out, that the relief sought is not Justice Klope must participate. The relief sought is don't do anything because he can't participate. But the argument is obviously bad for two reasons. The first is that the Western Cape Full Court has held that it can proceed. The point of the urgent proceedings, and this was abundantly clear in the papers, was abundantly clear to everybody who was in front of the Western Cape High Court, was that the applicants wanted the proceedings to go ahead next week, but we wanted them to go ahead without Justice Klope. That was the context in which the decision was taken. At paragraph 45 of the judgment, what the full court says is, during the intended sitting of the JSC, interviews for the position of Judge President of the Western Cape Division will take place, in addition to vacancies for the Supreme Court of Appeal and other divisions. Any participation of Dr. Klope in these interviews, it was argued, will undermine the integrity of the JSC and the public perception of its ability to perform its constitutional function. So our concern was, we want these to go ahead, but if Dr. Klope is there will be the real risk. And that's what the court ultimately upheld. And then in paragraph 68, the court said, in granting the same, the JSC will function in his absence, but if required, the NA may always designate another MP nominated by the opposition party to take his place. Irreparable harm befalls neither Dr. Klope nor the MK. So it says expressly that the JSC will function in his absence. Mr. Mainecha also took this court to paragraph 56. I'm not going to take you back there, but paragraph 56 of the full court judgment really makes the same point and shows that it considered the composition issue. It refers to the Premier of the Western Cape judgment. And it said, yes, despite that, there's no difficulty with composition. And the only argument I heard my learned friend, Mr. Mpofu, make in response to that is, well, the court said quorum, not composition. But that's an error of linguistics, not an error of substance. It was absolutely plain to the court what the issue was, because it was argued by, I believe, Mr. Masuku and Mr. Katz before the High Court, this precise issue, that Mr. Klope had to be there, otherwise there would be a composition problem. And we know it's a composition problem because the court refers to Premier for Western Cape, which is a composition case. Oh, sorry, I'm getting my wording wrong. It's an attendance case, not a composition case. We're beyond composition. It's an attendance case. So it's not open to this court to reconsider what the full court found. It's binding on all the parties here. And that should be enough. It so happens the full court was correct. And we know it was correct because of what the full court of this division said in the Klope case. Paragraph 39, Mr. Mainecha read it, I'm not going to repeat it. But it's crystal clear that when there are justifiable reasons for the absence, the JSC can continue, even if some of the members of which it is composed are not present. And so what Mr. Mpofu argued in response, to say, yes, but you must look at the SCA cases, Cape Bar and Premier Western Cape, and you mustn't look at the full court decision in Klope. That's wrong for two reasons. Firstly, because what the full court does is interpret the two SCA decisions. It refers to them in detail, and this court, as a single judge, is bound by their interpretation of the SCA judgments. It's not permitted with respect to go behind that interpretation and say, you were wrong in how you interpreted the judgments. But in any event, those cases say exactly what the full court says they say. There was a claim made that one of the members of my client, Ms. Helen Ziller, was flip-flopping because she was at the stage the Premier of the Western Cape, and she was making complaints about composition, and now she has no complaints. But it's important to go back and look at what happened there. What happened there is the issue that JSC was considering was the removal of Dr. Klopper, then Klopper JP. And Ms. Ziller, the Premier of the Western Cape, was not even informed about the sitting. So paragraph 4A, she was not present because the JSC had not notified her when and where the meetings were to take place. And she was unable to comply with her obligation to attend as required by section 178(1)K. So it's in that context in which the decision is taken, where you refuse to invite somebody. And the whole debate there was only about whether a Premier is required only for appointments of judges to that division or also for removals. That was what the case was about. It's interesting, at paragraph 21 of the judgment, the SCA says there was another potential difficulty about another absence. It says the Court of Quo also found that the JSC, again on its own version, was not properly constituted, and that one of the practicing advocates to be appointed in terms of section 178(1)E had not been appointed by the President. The point adds little to the previous one, and I prefer to leave it open, especially in view of the fact that it is not known why the advocate had not been appointed. So it's clear then that there's also an issue of, well, what is the reason why this person is or is not there? And then if we look at the Cape Bar case, the relevant paragraph is paragraph 36, where the SA says, I therefore agree with the Court of Quo's finding that in the absence of the President of this Court and his deputy without justification, the JSC was not properly constituted. So not only is this court, like the full court in the Western Cape High Court, was, well, I'm not sure it was bound, but it followed the decision here in Klopper, but they were correct in their interpretation of the two SCA judgments. So those are the two main pillars in this case, and they both fall completely flat. There's no merit to them whatsoever. And they created no meaningful risk for the JSC that would have justified it saying, because there's some remote possibility that sometimes somebody might bring a review of something that may or may not be unlawful, that may or may not lead to a remedy that impugns the decisions we take, we're going to waste 3 million rand and leave our courts unstaffed for months and months on end. And that's the rational thing to do. Because that's the applicant's case. That brings me to section 18. And the first point is that this really, whether the decision of whether the applications for leave to appeal suspended the operation of the full court's order doesn't matter. And it doesn't matter because the result of suspension would be that Dr. Klopper would be entitled to attend. And that's never been the demand, and that's never the relief. That wasn't the demand made to the JSC, and that's not the relief they seek now. And so it's really an irrelevancy, whether it's been suspended or not. So if they were correct that the judgment has been suspended because of the applications for leave to appeal, what it would mean is that Dr. Klopper is entitled to appear on Monday and say, I'm entitled to sit here. Not that the JSC shouldn't hold any interviews. But the second issue is, even if it does matter for some reason, we submit obvious that the decision falls under section 18.2, that it is an interlocutory decision that does not have the effect of a final judgment. And I think it's important to distinguish here between questions of appealability and the question of the application of section 18.2. Our law on the appealability of interim interdicts is, I think, somewhat contested at the moment. And whether the test might be different in the Constitutional Court versus the Supreme Court of Appeal versus appeals from the Magistrates Court. When can you appeal even if it's not final effect, if it's in the interest of justice? There's, as I read the law, some confusion on the issue.
Yes.
But
I mean, Zwini's a good guide to finality, isn't
Zweny is a good guide to finality, and that's the question
And
here.
the problem that you're setting out is that finality and appealability have been separated from each other.
Yes,
We just don't know how separate and in what circumstances.
but what we do for Section 18.2, because Section 18.2 is a statute that tells us,
Yeah,
and so that the test is there,
yeah.
does not have the effect of a final
For
judgment.
purposes of interim effect, yeah.
For the purposes of
Yeah.
interim effect, we don't have to worry about.
But Zweny's still a good guide to whether an order's final or not.
Yes, but the interim interdicts have always been regarded as interlocutory orders that don't have a final effect, and that's so for very, very good policy reasons, because otherwise there'd be a waste of time. Because I would go to court and get an interim interdict, normally sought in urgent proceedings, to preserve a position or alter a position for a period of normally months until final relief and an action or review or whatever it might be. And if that could be undermined by simply lodging an application for leave to appeal and then losing it, petitioning the SCA, losing it, petitioning the Constitutional Court, and that process inevitably takes up to a year, it would be an automatic right, effectively, of any litigant to suspend the operation of any interim interdict simply by pursuing their rights to appeal. And that's why Section 18.2 says what it says. Interim interdicts would be rendered nugatory if they were not, if they were suspended by the lodging of an appeal. There will be the rare case where an interim interdict is final in effect, because by the time you get to the review will be moot, or by the time you get to the action. Cronshaw is an example. This case is an example. If this court granted the interim interdict in this case, and we treated Part BB as a review, by the time we get there, the review is moot, because the postponement has happened as by dint of the interim interdict. It would be of academic interest only, the review. So if this court was minded to grant the interim interdict, there would likely be an appeal, and it would be final in effect, and it would suspend the operation of the order. But that's an unusual case, because of what is being sought to be reviewed is the postponement which will be achieved fully and finally by the interim interdict. But the decision of the full court is not like that. The decision of the full court leaves Dr. Klopper as a designee to the JSC. He's still a member of the JSC, and it lasts only until all it says is you may not participate until the review is determined. It's always the case that interim relief has a final effect during the interim period. That by definition, that's what it's meant to do. That doesn't make it final. If we say that is final effect, every interim interdict is final in effect, and that's never been our law.
Well, the question is whether it meets the three tests of
Yes.
finality. Disposes of a substantial part of the relief claim, is definitive of rights, not just that some things can't happen that would happen without the interdict.
Exactly.
Yeah.
And ultimately the rights that are at issue is, was the National Assembly's decision to designate Dr. Klopper lawful or not? And that is an open question that has not been determined between the parties, and will only be determined when the court determines Part B. That's the substance of the dispute. The Part A dispute was, well, what should happen until that substantive dispute is decided? Should he come or should he go? Should he be on the JSC or not? And that's classic interim relief. So we submit for those reasons that the Section 18.2 point doesn't get the applicants anywhere. My Lord, I'm almost finished. If I might have another few minutes, I think I can wrap up in the next 3 or 4 minutes.
Yeah.
That brings me to the requirements for interim relief. So just to take a step back, the primary relief sought is what is really the review of the postponement. It's called a declarative, but it's a review. It's quite strange, and it's final relief. It's quite strange to say, I want final relief. In the alternative, I want interim relief. Because if you lose on the final relief, how can you ever get the interim relief? Because the court would have made a decision that there is no right.
Well, I mean, that's why I had the exchange with Mr. Mpofu I did.
Yes.
That there are two different bases. The first is the rationality of the
Yes.
postponement. If it's irrational, that's a final declaration. In relation to the interim relief, it's the constitutional rights, mostly the Section 19 rights that the applicants say they have in these circumstances.
Yes, so I think as I read it, there's two bases sought for the interim relief. The one is the prospects of success in the review that's going to be in Part B, but if the court refuses the declarative, there cannot be no review. The other is the various rights that are asserted on behalf of Dr. Klop, on behalf of the National Assembly, on behalf of the JSC. Mr. Meinetz is quite right that Dr. Klop and the MK party can only assert their own rights. But with regard to that category of rights, that's been determined by the full court of the Western Cape. Because all these same arguments were made to that court. There was in the context of balance of convenience, Dr. Klop argued, you shouldn't preclude me from attending the sittings of the JSC because it will affect all these constitutional rights I have.
Yeah.
And the full court said, yes, we'll consider that, but we're going to preclude you from attending. And granting an interim interdict on that basis in this court would be to effectively set aside the decision of the full court. Because nothing new has happened other than the postponement decision, which is knocked out one way or another by prayer 2. And once that's either that they get that relief, they don't get the interim relief, or it's knocked out and therefore it's irrelevant to these other prima facie rights that are asserted. And that's the same case that was before the full court, just the other way around. That we were seeking to prevent him from attending and he's seeking to force his attendance. But the decision is the same. And the same goes for irreparable harm. That's also been determined by the full court. It says no irreparable harm will be suffered by Dr. Klop or the MK party. It says so in terms. On the question of alternative remedy, we've set them out. They can pursue their appeal, they can seek Section 18 relief in the Western Cape High Court, they can review the appointment of the designees, the 5 designees. And we also, we make the point, and we're going to stick to it, that they could have asked the National Assembly to designate a different member of the MK party to sit this week. This point was raised again in the full court in front of the Western Cape. The DA expressly said in its founding papers that if the relief is granted, the MK party will be entitled to go and ask the National Assembly, say, we want you to withdraw Dr. Klop's designation and designate a new person. And the National Assembly never said it couldn't do that. It was expressly put, it didn't say, no, we can't do that. It didn't say, no, we can't on functus basis. It didn't say, no, we can't on a timing basis. And we see no reason why they would be functus, because what you're doing is you're sending a designee. You can always say, well, I want to send a different designee. A party may say, well, yes, this person's B on the JSC, we'd rather now have somebody else, please designate person B. And that option hasn't even been exercised. The MK party hasn't approached the Speaker and said, please, can we urgently this week try and send a new person, a new member of Parliament, so that we have representation on the JSC. They've sat on their hands and brought this application instead. Lord, I was going to say something about remedy, but I think I've covered it in what I've said previously. On the issue of costs, we seek our costs. We seek the costs of 2 counsel. This may be constitutional litigation, but the applicant and the DA are private parties, not organs of state. BioWatch has no role here. It may with regard to the JSC, but not with regard to my client. We also seek punitive costs, because we submit that this is an abusive application. It should have been immediately apparent that the full court has dealt with this matter, and that the decision not to postpone was not a decision that could reasonably be said to be irrational in these circumstances, for all the reasons I've given. It's difficult to understand, given the way the case is structured, the way it was brought, why it really was brought, because the applicants never seem to actually ask for the relief they want, which is for Dr. Klop to be on the JSC. So we submitted it was an abusive application entitled to cost and attorney-client scale C, counsel.
Well, if you want attorney-client costs, you can't have costs on scale C.
Oh, then you have to say,
Scale C applies to party and party.
Yes, so if
somebody wrote
party and party. I believe so.
Yeah.
But those are my submissions.
Thank you. It's just after 1:45. I am going to suggest that we adjourn until 2, and then we hear from Mr. Duplessis. Thank you. Court adjourns.
Who's that?
You greeted that lady so nicely. Can't you ask her?
Which one?
The lady who's sitting there.
Oh no, I was greeting to me for the clerk.
Yeah, can't the clerk help?
I couldn't walk in, it was like this.
I feel like it's gotten worse.
But my father's didn't come outside and I tried to find
No freaking words. I don't think I need to. I think our stuff is safe.
Yeah, it's safe, yeah.
This is the last court, so I mean, I'm outside on the benches. I'm watching.
Oh, you're right, it's fine.
Oh, flipping hell, no, man. Look.
sure how we start again.
I still have.
Are you
Thank
sure?
you for offering a
Pleasure. Will you just give it to me? I'm not out of that one.
Half an hour.
Yes. You still have 10 minutes. 10 minutes. Yes.
Distinction thing over there. Tomorrow on.
Yeah. Sure. Oh, and the thing with the occupational thing, yeah.
Yes, I think my tongue will.
Yes, yeah.
One of those ones,
Yes. And all we wanted to say is what's about
I still going to push ahead with that review of the JSC Interholder decision.
Don't know, honestly. It doesn't seem like it needs to, right?
Well, that's
No, because, yeah, that's not fair. There was this promise that the JSC fix.
yes.
And they would, like, call for public comment.
Yeah. Did they? I don't know.
No, I don't think they have.
I'm not sure. Maybe I'll do it this time. Because this is their next big meeting. I'm not sure.
Yeah, I don't know.
Can you get a proposal?
The reason why I'm questioning them is otherwise I you can have two for your argument.
I won't have a butter biscuit. Give it to Dolly.
Yes.
Take mine.
Okay, thanks, Matt.
Tell Rebers and Boners I need to up their game. Snacks.
I think it's more cigarette.
Norton's is the gold standard.
Yeah, exactly.
It's actually Nina that's the gold standard. Nina and Mandla. So Mandla came in this morning acting as an advocate with a robe. Stashed with good
Have you seen this? The judicial.
I don't want to do anything. I'm using Dolly's words. I just follow my client's instructions.
You just what you missing out. Whoever pays. Okay, yeah. Yeah, this week. And I hope it's over. Sure. Even for me, that's what
I'm sure you were going to say there's nothing to reply to.
yeah.
I mean, where is that?
No, so far.
So far.
Let's see how next week.
Yeah, next week is
Our only hope.
Yeah. The last hope.
It's our only hope.
The last hope.
Act like I never
By the time your thing came at about 7.
Yeah.
That's when I was going to there might be a chance to do it midnight.
But they must be early and
Yes, exactly. Like even till 4 a.m. Yeah. In fact, what you do is you begin
I could it's
and
not
then
their
send it
fault.
at 4.
Yeah. How about the new job?
No, it was like this with those
Urgency issues.
All right, then, Claude.
Yes, Mr. Duplessis.
Thank you, my Lord. My Lord, I'm going to be dealing with 3 topics, and in some respects I can be obviously much shorter than my predecessors. The first topic is to explain to my Lord why there are no rights that have been shown by the applicants to justify their relief, no rights that, in other words, justify their declaratory stroke review relief,
Yeah.
nor rights that justify their alternative interdictory relief. I'm then going to turn, my Lord, to look at constitutional harm, which Freedom Under Law submits has been somewhat glossed over to this point. There are very important features of this case which my Lord would take account of in any exercise of judicial discretion.
Yeah.
And related to that, and then the third point, my Lord, is finally the question of costs. And I'm going to be dealing with that in the context of scandalizing statements which have been contained in a media report by the MK party. My Lord, let me start then immediately with the issue of rights. We have listened to the debate, and it really now seems to be common cause through my Lord's question is that the issue is the right to a rational decision, whether that is something the JSC rationally exercised when it decided to refuse the postponement. Lord, we say that the JSC was, Mr. Manetje says, correct. We say it was not just rational, it was perfectly rational in doing so. And my Lord, we say that because it had been confronted with a question about Section 178 and composition. That is set out in the letter by MK's attorneys that was written to the JSC in justification for the postponement. And I'll take you there in a second, my Lord. And the response to that was the reasons letter that we've already looked at by the JSC. Again, I'll have to quickly take you back to that. But my Lord, let me just immediately say that in any event, my Lord's point right up front is that all of this is an irrelevancy. This debate around composition is an irrelevancy in light of the fact that it misses the point. Because as my Lord put it, I think it was to Mr. Mpofu, the JSC is bound by the brute fact of there being an order of a court. That order of the court, it said that Mr. or Dr. Schloppe is not permitted to attend the JSC's meetings next week. But, my Lord, let me take you down into the debates, because we've had the benefit of those debates a couple of weeks ago in the Western Cape High Court. I can therefore give you, my Lord, an explanation for why what is in the Western Cape High Court's judgment is directly related to this very debate of Section 178. So, my Lord, let me take you, if I may, to the JSC's letter. And that letter is MM5. My Lord, we looked at it earlier.
Yeah.
And my Lord, you'll see that the JSC says that it had an urgent meeting, and it was noted, these are its reasons as we've been describing them.
the judgment of the full court did not set aside the decision of the National Assembly to designate Dr. Schlorpe as a member of the JSC and does not therefore impact the composition of the JSC. My Lord knows that. Whether it's a question of attendance or quorum or composition, that's how they understood the point. One can have a quibble about whether it's the right terminology in law. It doesn't matter. The point is they understood that was the issue. And then they said the JSC thus remains lawfully composed in terms of, and importantly, my Lord, Section 178 of the Constitution, and there's no violation of Section 171H. They go on to say at the top of the next page, while the full court has interdicted Dr. Schlorpe on an interim basis from participating, it expressly found that his absence would not render the JSC's decisions or processes unlawful. So, my Lord, they knew that the issue of composition and the interpretation of Section 178 of the Constitution was the issue that they were responding to. And, my Lord, it's not the case, with great respect, that that letter was what excluded Dr. Schlorpe. It was the court order. That's why they were talking about the court order. The proximate cause is wrapped up with the court order. We can't separate the letter from the court order. And, my Lord, the JSC looked, therefore, at the interpretation and the composition point. We know that from their letter and their reasons. And Mr. Mpofu, my learned friend, repeatedly said that this case is about interpretation, and that includes of Section 178. And, my Lord, the predicate for his relief, for our learned friend's relief, is that Section 178, properly interpreted, means what? That the JSC is not properly constituted without Dr. Schlorpe being present. That is the predicate for their entire case today. And, my Lord, our learned friend, Mr. Mpofu, said to us that we didn't understand his case and that the respondents were, unfortunately, misinterpreting his case. But with respect, we haven't, because if you look at the founding affidavit, paragraphs 82 to 83, I'm afraid to say, my Lord, in my hurried printing off, I didn't get the case lines version.
It's all right. Founding affidavit, paragraphs 82 to 83.
Yes, my Lord. So here you've seen, just before that, just so that you can go back, you'll see they are saying various things about what their rights are. And here, my Lord, you'll see at the top of the page, paragraph 79, they talk about Section 34, and then they talk about Section 36, and then Section 19. But here, my Lord, is the heart of their case. They say, most crucial, and in addition, the conduct is inconsistent with the clear provisions of Section 178(1)H. More particularly in that, the forced absence of Dr. Schlorpe will inevitably result in a major disturbance of the delicate balance intended to be achieved by prescribing that split between members of the ruling party and the bloc on the one hand and members of the opposition parties on the other, and the composition of the JSC as described by the constitutional drafters will therefore, or thereby, have been defeated, which is inconsistent with the relevant provisions of the Constitution. So, my Lord, that is their case. They say, most crucially, that's their case. And we've understood their case as that. The JSC understood the letter and the complaint as that. The JSC responded to it by saying, we've thought about it, and even read meetings must go ahead, even though you ask for Dr. Schlorpe to be there. So, my Lord, the problem is that for our learned friends, is that the interpretive predicate of their argument today about Section 178 is the same interpretive predicate that was advanced with trenchantly, I may say, and at length in the full court a couple of weeks ago. It was exactly those arguments. We were in those courts. Mr. Manetche wasn't. He wasn't because the JSC had abided. But I can tell you, my Lord, Mr. Bishop and I were there, and those were the debates, the very debates that are now the same debates that are being relied on to animate for the relief sought today. So, my Lord, in that context, let me then say that there are two judgments that have been referred to by all of us, which put the debate to rest as to whether it would have been rational for the JSC to consider that interpretational debate of 178 and come to the conclusion that we can't allow him to be there. It doesn't matter if he's not there, it's still composed, and it can still proceed in his absence lawfully. And my Lord, those judgments, the Lord knows, it's the JSC decision, rather the Schlorpe decision versus the JSC by His Lordship Mr. Justice Sutherland, Victor and Ledwaba. And Mr. Manetchi read to you, my Lord, from paragraph 39. And then you heard from Mr. Mpofu saying that the SCA Cape Bar Council is binding. And we also heard him saying that it has been binding because of its interpretation of the various provisions. But, my Lord, the interpretation has been done, and it has been interpreted by the full court, which with great respect is binding on my Lord, in relation to these very provisions. And I want to just please, with my Lord's leave, read to you paragraph 52 of His Lordship Mr. Justice Sutherland's judgment. I can't remember if it was, with no disrespect to either Justice Sutherland or Justice Ledwaba, whether it was Justice Ledwaba's judgment, concurred in by them. At paragraph 52, and we've heard our learned
Judgment
friend,
of the court.
Yes, a judgment of the court.
Paragraph 52.
Paragraph 52.
Yeah.
The court has looked at all of these debates, the ski road cases and new clicks, and it's looked at composition and attendance and quorum. But what is the principle of the case? The court comes to express a principle, which is the principle at the heart of this case. It's what Mr. Mpofu, our learned friend, says is about interpretation. He kept telling us this case is about interpretation. Well, let's see what the court said. It said at 52. And that goes to our next point. The need to avoid paralysis of the JSC. We are enjoined by the rules of interpretation not to interpret Section 178 in such a way that results in the paralysis of the JSC if a reasonable alternative construction is possible. Paragraph 53 goes on. So that is the interpretation that was advanced and accepted by that court, in contrast to the arguments that have been made on behalf of Mr. Schlopper, or Judge Schlopper as he then was. And that interpretational argument was ultimately resolved against Dr. Schlopper as he now is. And it was resolved in those terms by the court. So the full court, my Lord, has ruled that one has to avoid paralysis by the JSC, and that you have to avoid paralysis by an interpretation that avoids the impossible. And Dr. Schlopper's arguments today, with great respect, my Lord, seek to paralyze the JSC. Not, as Mr. Bishop pointed out, not to seek an order that he can return to the JSC, but that the JSC en bloc cannot sit. And my Lord, that is paralysis exemplified. And in that context, my Lord, you've got to ask this question. The JSC knew that the request that was being made of them in the letter by Dr. Schlopper and the MK's attorneys was to effectively have paralyzed the next week, and who knows for how long. And they looked at the interpretational points. They say so in the letter, 178, and they said, we're going for a different approach. And then the only question from the Lord is it a rational one? And we would say with great respect, of course it has to be rational. They've got in their favor the judgments which I've just highlighted for my Lord. They know that these very arguments were debated in the court at a full length. And they know that the court ultimately came to the conclusion, as it did in paragraph, I think it was 56 that everybody's read from the Western Cape judgment more recently, where in the end the court said at paragraph 56, I think Mr. Manetchi quoted it, the absence of Dr. Schlopper on the JSC would not be significant. There would still be 5 NA members represented on the JSC, constituting a majority of such members. That's the point. So, my Lord, the first point we can summarize is the following. There would be, through the interpretational arguments that our learned friends for the applicants propose, my Lord agreeing with them and paralyzing the JSC against the binding authority that I've highlighted for my Lord. But my Lord doesn't need to be concerned about that, because the only question before you is the rationality of the JSC's decision in any way justified? And for all these reasons, of course, it has to be justified. It would have been thoroughly irrational for the JSC to have done the opposite. My Lord, just posit this. The JSC says, thank you, we take your letter. We know we've spent all this money. We know all these people are coming. We know that there is a huge demand for judges to be obviously appointed to ensure the backlogs in the courts are fixed. We know all of that, but we're going to nevertheless adjourn. That would have been thoroughly irrational. So, my Lord, with great respect, there are no good reasons that have been advanced by our learned friends. There is a second point related to this, and it's the question of jurisdiction. We say this with respect to my Lord, but until Dr. Schlopper obtains a court order overturning the interim interdict that has been granted by the Western Cape High Court. Until he obtains that order overturning it, or he wins on appeal, or he wins in Part B, he is interdicted. Full stop. My Lord's point is the brute force of that order. And he cannot seek from my Lord to undo that order, because it's binding on him and it's binding on my Lord. As an order, orders of courts bind everybody. They bind my Lord as well, Section 165.4 and Section 165.5. So, my Lord, if he wishes to undo that, he has a remedy. My Lord doesn't need to feel as though you've locked him out of court and that Section 34 rights have been violated. His remedy lies in Section 18. He can go to the Western Cape High Court, the court that granted the interdict against him, effectively, and say and immediately allow for that order to be suspended, if that's what he wants to do. There's been a debate about 18.2, 18.3, my Lord. I don't want to take you back to that, other than to highlight the following, because again, our learned friend Mr. Mpofu said that we've misunderstood his case, and that clearly they don't need a Section 18.3 remedy, because just by having applied for leave, it suspended the operation of the order. But my Lord, that's not the position from their own letter. And some of it was read to you, but I need to take my Lord to it. It's MM3. It's the letter by the attorneys.
Yes,
you have it, my Lord.
Yep.
And if, my Lord, if you go to 02-121, paragraph 5. Now, these are the attorneys that are writing to the JSC, trying to explain to the JSC why the JSC must postpone next week's meetings. And look at what's said at 5. There again, at 5, they raise the 178.1H argument, Lord. No debate. They are wanting to retread those arguments. Second, my Lord, it says, the undesirable situation is exactly what will obtain unless before 7 October 2024, Part B of the High Court application or the Africa Forum application pending before the Con Court is heard and decided. That's gone away, by the way, my Lord. The Constitutional Court has said no. Or the National Assembly designates another person, assuming that it's constitutionally possible to do so, which they deny. And then the outcome, my Lord, of any application for leave to appeal and or proceedings in terms of Section 18 of the Superior Courts Act. My Lord, on their own letter, they explained that they knew Section 18 was where they would be able to avoid what they said was that outcome. So, my Lord, that's the Section 18 point. We've understood perhaps Mr. Mpofu's argument incorrectly, but that is what his client's letter said through the attorney. So, my Lord, let me then next say on jurisdiction that there is an insuperable further difficulty for our learned friends, and that's the judgment of His Lordship Mr. Justice Olson in my division, my Lord, in Durban, the Aqua Transport. My Lord, in that case, there had been a review, and excuse me. There'd been a review, it had been successful. There'd been a decision to apply for leave to appeal against that review's decision. There was then a separate case which was brought for an interim interdict. So the review had been before His Lordship Mr. Justice Lopes. There was a separate case brought for an application for an interdict, but like before my Lord, for an interim interdict pending the outcome of that appeal. That is effectively what His Lordship was dealing with in that case. And His Lordship, Mr. Justice Olson, refused it on the basis of the analysis that I don't know if you've had time to have a look at, my Lord, but it's in our heads of argument. I'd ask you to take a bit of time there. It's a paragraph 25 of the heads of argument that Freedom Under Law filed.
Yes, thank you on that.
So, my Lord, if I can just take you to the paragraph before that, because it's situated. Olson J. refused to do so on the basis that, given the extant judgment against the applicant had failed to prove any right to the interdict. He explained, I find it difficult to conceive of a circumstance which throws more serious doubt upon a claim that prima facie proof of the existence of a right has been established than the fact that the court has already adjudicated, in that case finally, upon the matter, determined that the right doesn't exist. But then, critically, next paragraph. Having made those observations, I still find myself in difficulty with the proposition that this court, sitting otherwise than as an appeal court, has the power or discretion in effect to overrule, or at least to second guess, a prior decision of this court in order to grant a temporary interdict pending appeal. And he said he wants to turn his face against that. Why? Because a practice or procedure which involves, like my lord, another judge, deciding the quality of prospects on appeal before the judge who heard the main case has decided whether the threshold of reasonable prospects of success on appeal is met, undermines Section 17 of the Superior Courts Act. He says that section carefully reflects the balance. And then you'll see the bolded point next. In my view, unless the application for the interdict is brought before the judge who made the decision subject to appeal, a glaring error on the part of the original judge must be apparent in most cases before interim relief is granted. Otherwise, there'd be nothing short of a whole re-hearing that would be required. My Lord, as we say...
Nothing in this case requires me to go into the full court's decision-making or criticise it or approve it in any way.
No,
and the question is, what is the effect of the order?
Yes, but in order to get to whether the order has that effect, there is the debate about rationality.
Yes.
And that debate engages the very debates.
The question of rationality is, did the JSC properly apprehend the effect of the order?
Yes, but in order for that to be answered, then we get back to the debates about whether it was properly understanding the interpretation of Section 178 and the debates that we've been having about those judgments.
I'm not sure that's right. I mean, the fact of the interpretation is different from its correctness.
Yes. But
so if one, the question is, there's the decision of the full court. Its order has to be interpreted in light of its reasons.
Yes.
Those reasons are presumed to be correct.
Yes.
In order to interpret the order.
Well, my lord, you've put it perfectly. Except you are being asked by the applicants to presume that it is not correct because of their arguments, which are the very arguments that were raised by them there but rejected by that court. That's the conundrum. So, my lord, the moment that position is clear, that my lord accepts the reasons as being correct and that those reasons justify the order, then there's no room, and this is the point. It's the same point with great respect that Justice Olsen was, I think, putting. There's no room for another court to have to go through that process.
As I understand the applicant's case, their case is there are two ways the JSC can comply with the order, a rational one and an irrational one. They say the rational one is to postpone all proceedings until the interim order is confirmed or discharged. JSC differs. That's the terrain on which we're having the argument, I think.
I think that's correct. And for the reasons that I've given, my lord, if that is the approach, then these are the other difficulties. If I may say, my lord doesn't need to get into these difficulties, but they arise unless one focuses on exactly what my lord has said. That's with respect.
Given the time that I have to decide this case, I think the shortest distance between 2 points is a straight line, isn't it?
Wilson's razor, my lord.
Sorry?
Wilson's razor.
Yeah. Well, I mean, you can call it what you want, but it just seems to me that I have what's been placed before me is a very narrow question of whether or not the JSC rationally exercised its power to refuse to postpone next week's, and I think the week thereafter's, interviews. And that narrows down the focus or the squint with which I must regard the full court's decision.
Yes.
The decision is not a disquisition with which I have to have a Socratic dialogue. It's just a fact. It's just there, and I must and I must put myself in the position of the JSC when it had regard to the fact of that decision.
Absolutely, and my lord, the question of whether the JSC's rationality arises from its understanding of what the court had decided.
Yes.
In light of the debate around 178.
Yes.
My lord, we're on the same.
Of course, if the case was that it completely misconstrued what the judgment and the order meant.
Sure.
But that's different from disagreeing with it, or criticizing it, or affirming it.
Yes. But a component of the rationality, and this will be my last submission on this, is whether it was appreciating what the alternative arguments were, and they are there in the letter. They knew it had been debated, and it was then asking itself, well, what is the alternative? And that is the debate that it ultimately decided on a rational basis was in favor of effectively agreeing with the interdict. So
Yes,
my Lord
thank you. I have that point, yeah.
Yes, my Lord. So then, in that context, my Lord, we say that the next important issue for my Lord to consider, and I needn't be long on this at all, is constitutional harm.
Yeah.
And I don't need to be long on it because my Lord has written the Nyazi Rail judgment, and we are aware of that.
Yes.
And we've cited it for my Lord in the heads. But my Lord, we see the constitutional harm as being particularly important. It goes, we heard the debate with our learned friends, and we agree with you, my Lord, it's the debate about where this constitutional harm fits. And it fits in two ways. It fits in, if it's an interim interdict, of course it fits in there at the outer level. But it also fits into the debate, we agree, on what is a just and equitable remedy if my Lord were to have to go there.
Yeah.
So my Lord, we say that there are, we've identified 5 harms. The first harm is a critical one, is that it's the rule of law itself which requires, obviously, that the judges be permitted, or the JSC rather be permitted, to fill the spaces, not just for the sake of filling spaces, but in order to ensure the constitutional end itself of the Bill of Rights being protected by judges who fulsomely are able to do so. The second harm, obviously, is for everybody that's having to come there, but now can't, from the Chief Justice to the judges, president, and so on. The third harm, my Lord, is, of course, the public resources that have been squandered. And the difficulty of trying to have these meetings. It takes months to set them up. We've heard the argument from our learned friends, but it can be done just another 2 or 3 months and it can be sorted out. Well, firstly, that's not the relief they're seeking. But in any event, it's simply not appropriate. There's no evidence of it, but the public evidence that we're all aware of is that it takes very months. The fourth is the administration of justice. And here, just on the evidence, my Lord, there is an insuperable difficulty for our learned friends on constitutional harm. Because Dr. Schlopper doesn't begin to address the irreparable constitutional harm at all. He doesn't do so. Versus the evidence that you've got, we all referenced earlier Mr. Nuka Torbe's affidavit. But if one looks at that affidavit, he personally says, my Lord, that he collated the evidence regarding the impact of the interdict on the functioning of the courts, specifically the Supreme Court of Appeal, the KwaZulu-Natal Provincial Division, the Land Court and the Labour Court, by directly engaging with the heads of those courts. So my Lord has that evidence from him through those judges. And my Lord, it's not a case of him creating an extra reason. The reasons are given. The JSC is providing you an explanation for why it thinks its reason was absolutely right. And it had already said that it wanted to continue on this basis.
Yeah.
So my Lord, those are submissions on constitutional harm, and they will weigh in the balance heavily, we say, with respect. My Lord, and then finally, on costs. And my Lord, we are not in the fortunate position of the JSC, who can be magnanimous, because as you'll have heard from Mr. Bishop, the DA has asked for punitive costs, and Freedom Under Law does so as well, my Lord. And they have been scandalized in this case, my Lord. Your Lordship knows that after the MK party and Dr. Schlopper were unsuccessful before the full court, they didn't seek urgent legal redress. Lord, what they did is they published the media statement. And that media statement, Lord, is for my Lord's benefit.
I've read it.
06235.
Yeah.
The statements that are made in there, my Lord, are scandalous, obviously, and they go to the very heart of the idea that the judgment is something sacrosanct and to be respected. And with great respect, we say that as a result, there are numbers of provisions of the Constitution which are immediately implicated. Not least of all because Dr. Schlopper is a member of Parliament, he's the deputy leader of the MK, he's the parliamentary leader, and of course we know then that those obligations on him are 165 and 173 of this court's powers to protect itself from such conduct. And my Lord, the difficulty is that we're not making, it's not just the content, it's not just statements that have been made in that media statement. It's the fact that it's a continuation of the same conduct that has been deprecated by the Constitutional Court. And Lord, in the answering affidavit by Freedom Under Law, but to take you there very briefly, it's at 06204, paras 27 to 28.
06204.
Yeah.
Yeah.
What happened there is, as my Lord recalls, the contempt case, and then after the Constitutional Court issued its judgment, statements made by Mr. Zuma. And the Constitutional Court said those media statements were put before it. They were recorded that it was admissible evidence, and it said this at paragraph 27. If the publication of these statements had no relation to him, he could have provided an explanation, either publicly or in these proceedings. He didn't. He even had an additional opportunity to dispute his connection to these statements after the hearing of the matter. However, to date, he has made no attempt to distance himself from those statements.
There's a letter asking I think, Dr. Schlope and Mr. Zuma to disassociate themselves from that
Absolutely.
press release, is there?
There is, my
Yeah.
lord. So there was a letter written by my clients to their attorneys, the attorneys for the applicants, saying to them, this is a statement that's been put out. It says these things about this judgment, and we would want confirmation as to whether you associate yourself with it. Now, my lord, what you have, and in light of that passage I've just read to you from the Constitutional Court,
Yeah.
saying, you have the replying affidavit that was filed and that came in, I can't remember if it was at 12 o'clock or 2 o'clock this morning.
I
Paragraph 31 of
already
it.
made clear what I was doing at 2 o'clock in the morning. Yeah.
Paragraph 31 of it, my lord, says
Yeah.
this. So, my lord, there's a further waving away of this. It says the long diatribe. It was a long diatribe. It just happened to be a very long statement. The long diatribe about alleged abusive process is disputed, and it's not worth the paper it's written on. It constitutes diversionary tactics which have no place in such proceedings. Well, of course they do when they are scandalous of the court and of your opponents. Then it says the letter marked FUL2 was unfortunately missed and will be responded to in due course. But then here, my lord, the final paragraph. Suffice to state the obvious, that neither Mr. Zuma nor Dr. Schlope are part of communications. The statements are always attributed to their authors. The witch hunt is therefore misplaced and misdirected. What there is not, my lord, is this paragraph consistent with what the Constitutional Court had said against at least one of the applicants.
Yeah.
Distancing themselves from the statement. Nothing there. So, my lord,
Your answering papers seem to suggest that the application should be dismissed toto as an abusive process.
no.
Now you're saying that this is relevant to costs.
It's relevant to costs as well as to the discretion that my lord can exercise.
Yes. In relation to the declaratory.
Of course.
Yeah.
So it's in relation to declaratory, and it's, well, there are three places it's relevant. It's obviously costs, it's obviously declarator, all declarators are discretionary, and it's also in relation to the interdict, because my lord knows the case law, that an interdict, even considering all the other factors for an interdict, a court can always take into account the questions of abuse of process in deciding whether to grant it. So, my lord, in those circumstances, we do ask for attorney and client costs, and the costs of two counsel. And I'm afraid to say I haven't read the luminous judgment about on the scale C, B, or A, but whatever the right scale is that
Luminous
accommodates
or voluminous?
luminous.
Oh. Might be voluminous as well, who knows? Yes, just on costs. You say that the attitude displayed to the full court's decision
Yes.
was scandalous and scandalous in the sense that it constituted a contempt.
Well, scandalous
Well,
against
scandalizing the court is it a form of contempt?
Yes, my lord.
Yeah, I thought it was.
Yes.
You say that means a punitive costs order in this case should be made. That's
Yes.
that's the level of the submission, is it?
That is it, my lord. My lord, we're not seeking to hold anybody in contempt or asking my lord to do so. But my lord cannot ignore, you sit in the same judicial branch of government as the judges in that division. You know what the case is about. It's clear before you that this statement has been made by the same parties that are now saying this of the particular judgment. And my lord, it's not that it was a scandalizing statement directed at the judges.
It was pretty clear it was about all judges, wasn't
Absolutely.
it? Yeah.
Blatantly political judgment of this court in respect of
I just worry
the
about
judiciary as a whole.
I just worry about deciding to attach penal consequences. Sorry,
We're not
penal
asking for quite that, my
just,
lord.
Just forget that word. I worry about attaching punitive, that was the word I was groping for, consequences to an exercise of expression that may or may not constitute contempt of court outside the context of a contempt of court application. This is a highly political case where the applicants are deeply frustrated, I think, would be an appropriate word, that the person they chose to sit on the JSC has been temporarily stopped from doing so. And they set this case up as a clash between those democratic rights and the Western Cape, well, the full court's decision to limit them, albeit temporarily, in terms of its decision. So against that background, there's a political ferment. And it's in that context that the press release was made. Now, the press release may well be contemptuous. It's certainly extremely strident. And Dr. Hlophe and Mr. Zuma may well, on the Constitutional Court's decision, be contemptuous in failing to disassociate themselves from it if they ultimately do. Ought that not to be the focus of a much more careful inquiry at the appropriate stage? I've had this case for 48 hours, and I'm being asked by you to say, well, I'm going to make a punitive costs order against Dr. Hlophe and against a party which is the official opposition in the National Assembly, largely because they said some nasty things in a press statement. That may well turn out to have been unlawful and contemptuous, but there is a difficult underlying question there about the barrier between contempt of court, the exercise of free expression in a political context. Must I determine those issues in this case?
My Lord, we would say with great respect, yes. The first is it's before you. And you've got the evidence that has been asked of Dr. Hlophe, and then by the letters and the response that I've taken you to. So, my Lord, you've got the evidence, one. Two, you've got the Constitutional Court authority in exactly the same situation. And in that case, my Lord, I want to double check the authority. I will, while my learned friend is arguing. I recall that was one of the reasons why the Constitutional Court said, not because of contempt of court, but because of that statement, that the court was going to, also as a court of first and final instance, by the way, issue punitive costs.
Yes.
And my Lord, the third thing is that it's not only the political nature of the context. Political contestation is always heated nowadays. It's the question of what is said about the courts and about your opponents. About the courts, it's not just the judge in question or the judges, it's the judiciary. But then about your opponents, they're racists, they're masquerading, they're white Malaki.
Yes, I don't want to be understood in any way as condoning those remarks. I don't. On the face of them, they seem to be well, it would have been better if they weren't made. But the question before me isn't whether those remarks are good or bad. The question is whether particular legal consequences should be attached to them in the context of these proceedings.
Yes.
Yeah. And I think you've made your submissions.
I've made my submission. I'll finish by saying this. My Lord has always in every case got to decide the issue of costs.
No, absolutely.
But these are the factors that go into the mix for my Lord.
But the ordinary costs decision is much easier normally. It's who won, was a constitutional issue raised, or has anybody misconducted themselves before me? Those are the usual costs inquiries. What you're asking me to do is take into account something at the periphery at best of that, perhaps even beyond that periphery, that involves penalising someone for the exercise of free speech. Potentially. Perhaps it will be appropriate in due course for whoever was responsible for that statement and whoever failed to disassociate themselves from it to be appropriately penalised. I just wonder whether it's something that's appropriate to take into account at this stage.
Well, my Lord, we've made our submissions.
Yes, and all I'm doing is opening my mind to you, just in case you want to try and change it a bit more.
I've given you my arguments as trenchantly as I could, and we stand by them.
Yeah.
Thank you.
Thank you. Mr. Ngolwana, is Mr. Ngolwana going to reply first, or are you?
My Lord, no, but if you can just make a request, Mr. Ngalwana may or may not address the court, but Mr. Ngalwana has asked me to make a request for a 5-minute break, and I'm conveying it because I might be the beneficiary of whatever he wants to decide.
Right, okay. Well, Mr. Duplessis was well within time, so literally a 5-minute break, 2:45.
Literally.
Yeah.
Thank you. That's correct.
Thank you.
But,
You're going to blame me for
oh, 5 minutes.
The most argument you get is on the scale of costs.
I took that as it's sort of like I may grant the declarator paralyzing the JSC, but I don't think I can get into cost.
But that was the thing he's most concerned about.
What's the reference? 0261. Max? Okay, no, but let me tell Max. Max? So, can I just say one word? One, catch you by surprise. In fact, I'm happy because I'm not the only one. We responded to that letter. Obviously, you're not aware. I'm sure you would have brought it to his attention.
You didn't put it in the affidavit?
No, it was subsequent. But what you don't know, for obvious reasons, because it was probably 2 a.m. or whatever, is that you actually did respond. So I'm Salon Friday afternoon. I might be taking something strong.
If you leave that job again forward, I mean, assume we finish it now, I need to get to Victoria. I'll start there.
You start on the Friday. Because you are staying rather than yeah, absolutely. It's the worst thing. Anything between on a normal day between 3:45 and so on, but on a Friday it's even worse. I think it starts even earlier.
No, I've got a hard copy.
You know that the worst thing last week I got my common sense because I always, you know, when you go in the morning it's all nice, and when you come back from court it's also nice. Then last week I had to go to the graduate business school or whatever. And I thought I'm going to Unisa. Then somewhere in the way I looked at this thing, I know it's in Interim. So I got myself into that other conflict. You think 20 guys for 20 minutes.
German people get very upset if they run their car for more than 20 minutes. It's a bad day. God's a big smile.
Growing up, I used to think it was like a 7 minutes. The way my family spoke about it, like a
Pardon? Do you want to start? No, only you. You can start the second. Did you get the references? I asked you guys for references. Yeah, but tell me. Just a minute. Do you have a pen? Okay, just a minute. I found one.
Our letter of the JSC.
Yes. It's at 0-123.
So you're saying this letter is okay? Wait, can I get? Let me get like a key. So this is
the letter to the JSC. It's at Justification and it's at.
Just a minute. So is it at case line?
That was the case we were a party. So everything's appropriate. And if you go for this one, you might
Anakshan? Letter 2. It's the letter 2, no?
Yeah, the letter by
Dash.
Some poetry have you negotiated?
We have, my lord, and I won.
So are you going to take all of the time? Or?
Yes.
Right.
Oh, well, not all, but I've got it. It's not a target, but at least I've got
you, Mr. Let's be precise about it. Mr. Ongolwana has ceded his time
yes,
to you.
That's correct.
You don't plan on taking all
absolutely
of it.
not,
Okay.
No.
Right.
Yes.
Thank you.
Yeah. Thank you, my lord. My lord, before I do start, if I may just clarify something. shall we call it, peripheral defamation. My Lord, the Mr. Duplessis was obviously not aware, just as I was not aware of his letter, that we did respond to that letter. And I was going to read it into the record, but my Lord, it's just been uploaded, if your Lordship will accept it. And it's at 02-62. It's just to say that there was a response. It's whether it's a good
62
at 02-62, my Lord, yes.
0262.
02-262. Oh, yes. 02-
Oh well, no, it's that I have something labeled correspondence here at 02-60.
60-62. That's correct.
Yes.
Yes, my Lord. Yes. And I'm not going to belabor the point, my Lord, simply to say, because to the extent that the accusation is that there was a non-response, which might suggest like nonchalant behavior.
Yes, this is what's referred to in reply, isn't it?
In a way, it's
well, you say it fell through the cracks. We will respond in due course.
Yes,
and this is the response.
Take instructions.
This is effectively a response saying we will respond in due course.
Yes.
Yeah.
All I'm saying, my Lord, is that it's not what it might look like was that look, you just take it and throw it in the dustbin. That's not what happened.
No.
And Mr. Duplessis, my learned friend, was not aware of that response. No. Obviously, he would have brought it to the court's attention.
Thank you.
Thank you, my Lord. Okay. Now, my Lord, I suppose I must first be indebted, before I'm indebted to your Lordship, to be indebted to Mr. Ngalwana, because his approach, my Lord, is going to allow me just to do a little bit of an extra, hopefully 10 minutes to situate the case. Because with the greatest respect, my Lord, and I'm not saying this flippantly, nothing that I have heard from my learned friends, all of them, suggests that my remark in the morning that we are at cross purposes, and I'm prepared to take some responsibility for that. Maybe we didn't clarify what this case is about. My Lord, let me start here. It is the duty of a court, any court in South Africa, shall we say, to prevent and avoid the denial of human rights. Goes without saying, none of my learned friends can quibble with that. And that's the only reason we're here, my Lord. Well, we might be right, we might be wrong, that's a different matter. But all we're here for, my Lord, and nothing else, is to say, court, my human rights have been violated, and court, because you are the only person who can intervene, save for me going to self-help.
Yes, please don't do that.
Thank you, my Lord, I promise.
Yes.
You are the only person who can intervene one way or the other, and the court will say yes or no, as courts always do. Yeah. But really, that's all there is to it. And in crafting that plea to the court to intervene because our human rights are being allegedly violated, we then say, my Lord, the manner in which those rights are violated manifest themselves twofold. In the first instance, they manifest themselves by a violation of the rights in the Bill of Rights. And I don't want to go through the list. I said section 1C, 9, 10, 34. I'll just stop at that. If we are right about that, then we are entitled to relief in terms of section 38 of the Constitution. And it ends there. And we are also entitled to appropriate relief. That's all. And section 38 is so lenient that it says if you have a right violated or even threatened to be violated. So even if we came here, my Lord, and we said, look, we're not sure if our right is violated of section 19, but it's threatened to be violated, the Lordship would still give us appropriate relief. So let's close that chapter. That's the Section 38 case.
Yeah.
We then go further. We say, my Lord, assume that none of our Bill of Rights have been violated. But there has been an irrationality, which, as your Lordship said earlier, is 1C, not Chapter 2, Chapter 1 now of the Constitution. 1C, and we say there's been other violations, there may be all over the Constitution. And if we're right on that, that's the irrationality decision thing, then your Lordship must come to our rescue, but this time in terms of 172(1)(a. Right. And then we say, my Lord, if your Lordship cannot find, if your Lordship says no, neither your Bill of Rights have been violated, nor your other constitutional rights, then we say the court, nevertheless, on the Van Warmelo test, the court is still capable of giving us 172(1)(b) relief. I won't develop it. I did that in the morning. Now, my Lord, that's all, and we may be right, we may be wrong. We're prepared to accept that. But our case must not be mischaracterized as something else. And our case is not, I repeat, not to second guess, attack, criticize, backdoor, appeal, and so on, the decision of the Western Cape High Court. But your Lordship, in a way, took the words from my mouth. But just as we, my Lord, cannot say that that judgment is wrong, just merely because it's on appeal, my learned friends also cannot say it's right. So what we accept is what your Lordship correctly beautifully put as the fact of the judgment, that nobody can wish away. It is there, and it must be taken at face value. The other thing that is true about that judgment is what your Lordship said to my learned friend, Mr. Duplessis, which is that in its interpretation, and that's the Firestone cases, Gentoo, Kuro, and so on. All the cases we've listed, SOS, Constitutional Court. In its interpretation, you have to look at the order and you have to look at the reasons. That's the trite. So your Lordship can't just say, I'm looking at this order, it says you must wait until the end of the Constitutional Court, and that's it. The Lordship will have is bound to on the endumeni test to go to the reasons that are given and to interpret the judgment. And quite frankly, my Lord, it doesn't matter at all what was argued in Cape Town by either the DA or ourselves or whatever. The test is objective. So the DA might have gone to court to look for 3 cars, but the judgment is about 1 car. All of that is irrelevant. Your Lordship is guided by the objective wording of the thing, the context, the usual endumeni things, and to interpret that judgment. Now, so when Mr. Ngalona says, look at the judgment, it says MPs, and it says 1 designation, and it says the designation, my word, is indivisible. Then that's it. It doesn't matter that the DA went there only to hunt for Dr. Hlophe or whatever. But if the judgment came out that way, it came out that way. Of course, Mr. Maneche is also correct to say that there may well be some other readings, such as paragraph 56, where they say, oh, well, the other 5 will be there and so on, which go the other way around. That's fine. I'm prepared to do that. But your Lordship, both on Mr. Maneche's pinpointing of certain paragraphs and Mr. Ngalwana's pinpointing of certain paragraphs, must objectively, yourself, my Lord, say that this is what the impact of the judgment is. So I just wanted to clarify that. Now, and it's not about the correctness of the judgment either. Now, there's another small red herring that was used here. My learned friend, Mr. Duplessis, I think. Oh, no. Let me stick to this. My learned friend, Mr. Manager, says correctly, assuming for now he's right on the Section 18 discussion. He says, and it's quite correct that there were parties in the Western Cape High Court, but not in the Constitutional Court, where they were not cited. but all my learned friends make the same mistake. So they say, well, that judgment is binding on the JSC. Of course it is. It's binding on me as well. But that's not the question before your Lordship. The question is this, and everyone is eliding this question. The mere fact that there is a binding judgment on the whole world does not mean the JSC is forced to do something. Let me repeat that. The mere fact that there is a judgment of the Western Cape that's a non sequitur. Does not mean that the JSC must decline the postponement request. So it's not bound in that sense. The Western Cape judgment never said the JSC must decline the postponement request. Or put differently, if the JSC granted the postponement request, it would not be breaching the Western Cape judgment.
Yes, you accept the way I put it to Mr. Duplessis was there are two ways to comply.
Absolutely.
One is to continue without Dr. Chlorpe, and
yes.
One is to not continue
absolutely.
Until Dr. Chlorpe can participate. And the
yes.
question is whether the JSC's decision to continue without him is rational.
100%, yeah. So, but the way it's being formulated in this court is as if the existence of the Western Cape judgment means that the JSC's hands were tied vis-a-vis the postponement. No. The JSC, while complying with that judgment, could have said, yes, we're going to... Nobody would have said, you're in breach, you must go into contempt, go to jail, and so on.
I mean, that's obvious because, as I understand it, minority of the committee of the JSC that made the decision.
Yes.
So
absolutely.
We should postpone.
100%.
But they should postpone.
Yes. And
no.
Absolutely, my lord.
It clearly has to be approached on the basis of the fact of the judgment and the rationality of
absolutely.
The JSC's response to it.
That's all. That's all. And your Lordship, no, I won't belabor the point. Your Lordship has hit it. The mere fact that some of the members of the JSC said, let's postpone, doesn't mean that they were in contempt. They just were outnumbered. But there's no right or wrong. Yeah. All right. No, then it's clear, my lord. So let's get that red herring of being bound, quote unquote, out of the way. So to give, and that's what we mean by material error of law. So for the JSC to think that they were bound in the literal sense, that they had no option but to refuse the postponement, or to give that as a reason, is itself a material error of law.
Does that interpretation arise from its letter?
From this letter, yes. So the preamble, not the 2.1, before 2.1, just the preamble.
Considers itself bound by the judgment.
Yes, yes. So that's where that once you made that big material error, everything goes south, because you are thinking that you are bound in the literal sense. Now, my lord, the funny thing is this. You remember that in the JSC's answer, they say what we are missing is that they had a discretion, and they exercised the discretion, and I agree with them, by the way. They exercised that discretion just as it's funny how these arguments turn around. When we said in the Western Cape judgment, of course, the National Assembly had a discretion to whether to designate or not designate. That's why they put it to the vote. That's exactly what the JSC did correctly. They would, if they thought they didn't have a discretion, they wouldn't have put it to the vote. They would have just said, we don't know what these people are smoking. And we obviously can't do this, and so on. But the mere fact that they put it to the vote means that they had a discretion. But in the same breath, they're telling you they didn't have a discretion because they were bound by the Western Cape High Court decision. So it's just a mishmash of irrationality. Now,
well, I mean, you've got to interpret the letter as a whole, haven't you?
My lord?
You've got to interpret the letter as a whole.
Yes, of course, of course. No, but I'm just dealing, yes, no, fair enough, my lord. Yeah. But I'm dealing it the way Mr. Manager dealt with it, that effectively there are three reasons. The first one is that they are bound. The second one is the one that I'm going into, Cape. So they say, well, MK, in their own letter, say that they're not sure whether it's 18.1 or 18.2 and so on, and it may or may not be binding. What have you? You heard all the submissions. But they forget one thing. You know, people sometimes make elementary mistake. All they need to do, not to make that absurd suggestion, is to look at the date. That's all. That's all. The date of that...
Does it really matter what the MK thought and when it thought it? The question is objective.
Absolutely. Firstly, it doesn't... exactly, my lord. Even if MK said, we are bound, it would be... the law is the law. That's the first point, my lord. Yeah. But the second point, which is even more important, is that at that point, the application for leave to appeal had not yet been served. Yeah. So... But all my learned friends argue this matter as if those applications had already been served. So at that point, theoretically, and I'm saying this very theoretically because it could not have happened. Theoretically, MK could have even said, no, we've decided no longer to appeal or whatever. I'm just using it theoretically. But as it happened, once they then lodged their application for leave to appeal, then Section 18.1 triggered itself on our version, or 18.2 on their version. That your lordship will decide that. But nobody must come here and say that in your own letter you don't say, because that letter precedes the filing of the... Okay, so at least let's get that out of the way as well. If your lordship goes to 02132, you'll see two things, Mel. 02.
The application for leave to appeal.
Sorry, okay, mine seems to be in a different place. 02. Yep. Okay, I've got it on a different place, my lord. But and I don't want to waste your...
At 02-132.
132.
I have an application for leave to appeal. Is that what you want to take it for?
Okay, then my numbering is wrong. Okay, so I'll just use the natural numbers.
Give me the document and the paragraph number.
Yes, okay, my lord. It's an annexure to our notice of motion, I think. Yeah, I don't. Oh yes, okay, it's in the wrong place, so I'll just refer to it to. So on at paragraph, let's start with the face of that. On mine is on 0285 for some reason. So it says notice of urgent application for leave to appeal.
Oh right, yes, no, that's what I have.
That's the one, yes. And then it says the usual take notice and so on and so on. And then further it says, and this is now, remember the subsequent, take notice further that the said decision, which has final effect on MK and or Dr. Hlophe, will be appealed on the grounds set below. And that's the issue. So again, that might be right or wrong legally, that's not the point. But the appeal is brought on the basis that that decision has final effect on MK and or Dr. Hlophe. In other words, it's a Section 18.1 situation. I just wanted to point that out. So there is no world in which the MK was now, having said its final, in fact, bring an 18.2 application.
No.
Yes, because it was effectively saying we're bringing this. In fact, those words, it might as well have said we're bringing this under Section 18.1. That's what it means. Yeah. So that's the other red herring out of the way. Then, my lord, I agree with one of my learned friends, I think it's Mr. Bishop, that there is usually a confusion, and this debate is very complicated. It looks easy about 18.2 and interdict and final effect, Zweni, and so on. But there's always a confusion between the issue of appealability, which is one thing, and the application of 18.2. Those two things are not the same, contrary to popular belief. And I'll illustrate why they're not the same. Appealability is implied in 18.2.
Yes.
And because we didn't need 18.2 if as Mr. Bishop says, all interlocutory orders were not appealable.
It's not even about that. It's about what happens when a party applies for leave to appeal against any order.
Absolutely.
Whether it's appealable or not.
Is another
whether
question.
It's final or not.
Exactly.
And the question is, what immediate factual effect does the application for leave to appeal have?
Absolutely.
If the order is an interlocutory order not having final effect, it's not suspended.
Yes.
If it's an interlocutory order having final effect,
it's suspended.
It's suspended.
Simple.
If it's a final order that doesn't pretend to be interlocutory,
there's no debate.
Yeah.
Yes.
So I don't think that we need to sort of delve too deeply into the theoretical debates about appealability and finality.
Yes.
It's fairly clear to me.
But it's important only in this respect, madam. If we are correct that one of can't remember which of my learned friends say interim orders are always non-appealable. That's not true. Even interlocutory orders, that the point I'm making, that even pure interlocutory orders, if they were always not appealable, then why would we have something called 18.2? Because that postulates an appeal. I think
that was Mr. Bishop. He said, in almost all cases,
yes, always. He used the word always.
Are not appealable, but where they have final effect, they are.
Absolutely. Thank you, my lord. I'll move on. Yes, I'll move on. Then, my learned friend, Mr. Manager, gives me what we call a backhanded compliment, because in the Moyo case, we succeeded to distinguish between 18.1 and 18.2.
Yeah.
And for a change, the other side's argument was described as fascicle. But that's a non-example, because in Moyo, it was exactly this debate, and we went into CPLA and all those cases about appealability. So the issue in Moyo was appealability, not what we're debating here today.
Yeah.
And as it happened, that victory that Mr. Manager was attributing to me was on the question of appealability short-lived, because as everyone knows, within a few months of that, the appeal happened, and it was actually reversed. And we even tried to go to the SCA on the basis that we should not have lost that appeal because it's not appealable, and the SCA said no. So that just shows that this thing is a slippery issue. Right. Then, my lord, there's another, this popular paragraph 56 that everyone is misreading. Paragraph 56 of the judgment says the respondent's submission that the JSC would not have a quorum in order to take valid decision if Dr. President declared from participating in that forum is incorrect. And then it goes on. Later I'll just read the part that Mr. Manager said I didn't read, and to show that it actually assists us. one of my learned friends said that is I think it was Mr. Bishop. I think Mr. Bishop is was being creative, to put it mildly. He said that this was a linguistic error. Yeah. But you see, you can't have it both ways. You can't say the judgment of the Western Cape, we must take it at face value when it suits you. But when it doesn't suit you, you point to a so-called linguistic error. There's no linguistic error, or if there is, it will be resolved in the appeal.
Yeah.
But for the purposes of your Lordship, that paragraph deals with quorum. It does not deal with composition. It doesn't deal with Mr. Bishop, so that I can buy his favor now. Also correctly listed.
Is it for sale, Mr. Bishop?
Yeah, it is for sale. He only has one leg to stand on. And Mr. Bishop gave a list. He even increased my list. He said there's the issue of composition, which is true.
Yeah.
There's the issue of quorum, and then he included there's another issue of attendance.
Yeah.
And Mr. Bishop is obviously correct, and that's why he had to find the linguistic error trick.
Yeah.
Because those three things are completely separate. The point of the matter is that even assuming, which we have to, that paragraph 56 is correct, it only deals with quorum. It doesn't deal with absence. It doesn't deal with composition.
Yeah.
And it certainly doesn't deal with what is called in the Bar Council case, the delicate balance that is sought to be struck by the Constitution in constructing, in designing, I think is the word they used, the JSC. Move on. Then, all my learned friends, no, this is Mr. Bishop again. Yeah. Okay, I'm also going to be in his bad books again. Yeah. He says that the DA says about the other 5 people, no, we like them. That includes Mr. Malema. So we'll take that with a bit of pinch of salt. Yeah. But in that formulation, my lord, what the DA is doing on a more serious note is mixing up the issue of the remedy and the declarator. Because of course, my lord, I cannot stand here and say to your lordship, when it comes to remedy, your lordship must not take into account all these things. Is the sky going to fall and all that? I can't. Because when it comes to remedy, your lordship must do that. But when it comes to the declarator, your lordship does not have that option, because the constitutional writers took it away from your lordship by using the word must. So all the Mr. Ngaitobi considerations and so on, of course, they'll be relevant in the discretionary part of the thing, but they're not relevant for the declarator. And this might even be an argument against myself, but I have to make it in fairness. I accept, my lord, implicitly, that, I think it was Mr. Bishop, that the likelihood is that the sky is not going to fall. Because courts, either way, by the way, there's no sky that's going to fall. Your lordship simply has to weigh the balance of convenience. And I'll make 2 illustrations. One, it is that there's been a vacancy, I think, in the Constitutional Court for 4 years, and the sky has not fallen. So if the vacancies are not filled in 2 or 3 months or whatever, the sky is not going to fall. But against me is the same argument. The sky is not necessarily going to fall if there are, let's call them invalid appointments. Because your lordship and everyone here knows that in the so-called NTPP cases, the courts under section 172(1) always fashion a remedy, which says, I think the Simelane case on Masana and so on, it always says, okay, this appointment was invalid. But for good governance, you can't say this NTPP is invalid. Therefore, all the criminals who have been prosecuted in the last 6 months can walk free. Nobody does that. Yeah. So the court will always accommodate those sky-falling things and deal with them in terms of 172 1B. Then, my lord, so I'm just trying to go to the. Oh yes. I don't intend to give a lecture on this, but I have to say this. If the law is very simple, if we are right that there's a prima facie or threatened right, section 19 or whatever, then all your lordship has to do is to do what is known as a limitation analysis. So your lordship will have to say, okay, your right to participate in the forthcoming interviews translates into your right to participate in the political activities of your choice, section 19. So prima facie, it will be limited. And that's all that is needed, my lord. Limited. That word was chosen deliberately in section 36. All we need to show, my lord, is that that right will be limited. And it says in this book of Carré and Duval, I don't know if it's the latest edition. Limitation, page 151. Limitation is a synonym for infringement or perhaps justifiable infringement. And here's the important part. It says a law. So even the court order, let's call that a law. A law that limits a right infringes the right. Let me read that again. A law that limits the right infringes the right. So a court order that limits the right infringes the right. So you can't have a circuitous argument that says, no, it's justified because it's a court order or a statute or a whatever. Because if it limits the right, it limits the right. And then it says, however, the infringement will not be unconstitutional if it takes place for a reason that is accepted as a justification for infringing rights in an open democratic society based on human dignity, equality, and so on. And where an infringement can be justified in accordance with the criteria in section 36, it will be constitutionally valid. Then I'm jumping to the bottom. If rights can be overridden simply on the basis that the general welfare, which is what we're told here, will be served by the restriction, then there's little purpose in the constitutional entrenchment of rights. Yeah. So all these big stories were told, oh no, the judges or the burden of the courts are going to all crumble. The general welfare, they say if you were to take those into account, then what's the point of having entrenched rights? And then said, but however important the purpose of the limitation, restrictions on rights will not be justifiable unless there's a good reason for thinking that the restriction would achieve the purpose it is designed to achieve, and that there is no other realistically available way in which the purpose can be achieved without restricting rights. In other words, to bring it home, we will have to show that there's no other realistic way, such as the postponement that you are proposing, in which you could avoid the limitation of rights. And our case is that there is. Now, here's another one, Melon. We are now being beaten up for being realistic. So my learned friends say, well, you should have then just come to say, no, we want Dr. Hoppe to be there on Monday. Of course, we could have done that. But how can we be punished for doing that which is responsible citizenship? Where we are saying, we may be right, Dr. Hoppe might be entitled to go there on Monday. But no, we don't want to take that option. We're saying, let's all hang ten until there's clarity. And now my learned friend says, you know, well, you should have demanded that we're going on Monday, or walk in, or do a sit-in, or I don't know, whatever. But the only thing we're asking is for rationality. And we're saying, Given the shortness of time, the fact that we cannot do, even if we were to do a Section 18, neither us nor you can do a Section 18 in 4 days. Parliament is in recess. The meeting is next Monday. It's not a creation of our own that the judgment was only given on Friday. We are all been put in this situation. Given all that, let us take a via media of pausing and making sure that nobody's rights are infringed or limited. And then they say, no, you should have gone for the jugular and cut our necks. We don't want to. You can't force us to do something, because we are mindful of these issues, my lord. It might well be, what if Dr. Kloppe goes there on Monday, possibly or otherwise, and then a week later there's Part B, which says he should not have been there, as we've said. Then you have the flip side of the problem. So all we are saying is, no one must be put in that situation. If Dr. Kloppe is right, don't prejudice him by permanently removing him. And by the way, this thing of final effect must be addressed. It might look on a piece of paper as an interim or permanent or temporary setback, but the reality is that, and that's what we mean when we say it has final effect on MK and Dr. Kloppe. If the meeting continues without Dr. Kloppe, it is irrecoverable and irreversible that he would have been deprived of participating in those interviews. So it's final in effect in that sense. Similarly, MK's, I was about to say bragging points, but it's more serious than that. MK's right to have its member sitting in these interviews would have been permanently and irreversibly, till thy kingdom come, have been...
That's right to have that particular...
Absolutely.
Yeah.
Yes. So that's what we mean by final in effect. And we're talking about human rights here. We're not talking about some frivolous thing. So if you deny or limit, I prefer that word for obvious purposes. Yeah. If you limit that right even to that extent, that has a permanent and everlasting effect. Then, my lord, on a lighter note, we were told that Mr. Trenkov made a transient submission, and my learned friend corrected himself that when he said it was cogent, it was obviously not cogent because he lost the point. Yeah. And that point was this: Mr. Trenkov's client FUL and Mr. Du Plessis, for that matter, was saying that they should be given final relief alongside the interim relief, and the court, in a balancing act, found against them and said no, we'd rather postpone that to Part B. So that's that's what happened. So that and then, my lord, we're also told that, but against Mr. Ngalwana, it is said that you have not challenged the other 5. But we've said this in our, I know your Lordship hasn't read our reply, but when your Lordship does, we'll make the following point. And I can say this from the bar, I hope, unless my learned friends object. We do hold instructions, my lord, to challenge the other 5, if you like. And the only way we can do it, and because one of my learned friends, I think Mr. Du Plessis, correctly analyzed the situation in his affidavit. What we do, my lord, is what is called a conditional counter-application. Because obviously, and one of my learned friends was correct to say that you can't blow hot and cold. So what we're going to say is to say, if we are wrong on the Ngalwana argument, then conditionally, then the other 5 are also tainted. But here's the point. You can't do that now. You can only do that when we answer to Part B. Because we'll do the conditional counter application as part of that. We're still far from that. They have not even done the supplementary affidavit in terms of Rule 53 and all that jazz. So when all that happens, we will then do the Rule 53, and as I say, even from the bar, we will then attack that issue. So you can't criticize us now. How are we going to do it? Let's say we wanted to attack it. We can't. It's too early. If you want to criticize us, just wait until you get our answering affidavit. Then, my Lord, I'm coming towards the end.
Yes.
Your Lordship really hit the nail on the head. Now, before we do that, let's go to Mr. Bishop. Mr. Bishop cites the case. There's some the case of the public protector. It's some case here in which I was gratuitously insulted. Now, that case, my Lord, is not authority for the proposition that Mr. Bishop says it is. That case, what happened in that case is that in the, actually that case works against him. In the High Court, in the full court in the Western Cape, the public protector said, there's been bias and all sorts of things. Somebody's husband was judging me and it should be reviewed on that basis. The court, in our respectful submission, wrongly, and I say that boldly because that process, that case is still in the appeal pipeline, so to speak. So it may be confirmed or not confirmed. And that's another reason why Mr. Bishop may not rely on it. I can put every cent I have that that case is going to be appealed, if nothing else, because the client is aggrieved. Me, I'm fine. So what that court said it said it's in medias res, because the Section 194 thing is still running. But the court did something which, and I don't want to criticize the court gratuitously and do the opposite. The court did something that should not be done, which, imagine if your Lordship said this, I'm not going to give you the declarator, and that's it. And therefore, I'm not going to look at prayer 3. That's what that court did. So it was blatantly wrong, because it said, it's in medias res, and therefore we're not going, and Paja doesn't apply. Therefore, we're not going to look at legality, which is bizarre. But that court was not authority for the proposition that a decision, which Mr. Maneche, to his credit, has never said that it's not a decision, because it is. A decision is somehow in medias res, or is not an administrative decision. Which, by the way, in case I forget at the end, deals also with the question of costs. I mean, this is the biggest irony. Mr. Maneche, who's my real opponent, says he's not looking for cost orders. And then some people who just came for a reason that we cannot understand. Yes, but on the basis that only if you oppose, I'm sorry, my Lord, I shouldn't be responding to the banter. Yes. but let me say this, my Lord. The reason why, paragraph whatever it is of our founding affidavit says exactly that from number 2 to number 22, they are only cited of any interest they might have, but no relief is sought against them. That's the point. So the only relief that was sought was against Mr. Maneche. I know they were cited because I'm the one who cited them. But the point is that what is the DA and FUL? Why? What is their business about whether there should be a postponement or not a postponement? They said in Cape Town they were protecting the rule of law, fine. And
I think their view is the rule of law is best protected by the JSC proceeding without Dr. Klorpe.
Aha.
Might be right, might be wrong, but that's why they're here.
Exactly. But that's exactly, remember the shoe is now on the other foot.
Yeah.
We are also here now to say exactly that, my Lord. We're here to say the rule of law, rationality, will be best served by reading the letter of reasons of the JSC, and on its assessment, make declaring it to be irrational. That's exactly. So the only reason we're here is of course to protect the rights of the principal parties. But the broader reason, which is why 172(1)A applies, is because we're here to protect that rule of law. So they can't say when it was their turn, rule of law, and then now when the Dr. Hlope and MK say, well, the rule of law says that we should postpone, then they say no, go forge ahead, break the rule of law. Now, yes, I have to say this about Mr. Du Plessis so that Mr. Bishop doesn't think I'm only picking on him. Mr. Du Plessis' client misses the point, really, by a mile. Because their case is untenable. Their case, they say, the court has a discretion on the declarator. The court doesn't have a discretion on the declarator. They make that mistake because they miss the law. And you can see why they miss the law. They rely on Ogbay, on that case of Ogbay, the Gupta's case. That case, my lord, was not brought under Section 172(1)A or even Section 38. It was brought under Section 19C of the Superior Courts Act. In terms of Section 19C of the 191C of the Superior Courts Act, of course, the court has a discretion to grant in what we call an ordinary declarator. But that's not what we're talking about here. In this case, we're talking about Section 172(1)A of the Constitution. So Ogbay has got nothing to do with what we're discussing here. And then yes, Your Lordship, to one of my learned friends said, and this is hopefully the last point, when I was saying Your Lordship hit the nail on the head, Your Lordship summarized it as follows, and I'm going to borrow the words from Hoekstra and Penfold. The relief that we seek has got two pathways. Can't remember the word Your Lordship used, but it's something to that effect. And these pathways must not be confused. Mr. Manecha, I'm picking on him now, makes the fundamental mistake of not appreciating the gravamen of the Hoover School van Warmelo case. Mr. Manecha says wrongly. It doesn't matter whether you are looking for the common law right or whether you are looking for the constitutional interdict. It's all the same test. You have to apply the same test. No. And the authority for that, my lord, is a case called EFF versus Godin. EFF versus Godin makes it clear, my lord, that there are three things. There's what we call the normal outer test. There's a Section 172(1)B van Hoover School Ermelo type. And then there's a third category, my lord, called suspension. So if Your Lordship in your wide discretion can say, I'm not doing any of the things that Mr. Mpofu is asking me to do. So I'm not going to give you a common law interdict, and the pun is not intended, interdicting the interviews. I'm not going to give you a common law interdict, and I'm also not even going to give you a Hoover School Ermelo relief. But I'm going to give you relief that says that the interviews are suspended, or suspend the decision, the non-postponement decision. And I'll show you, my lord, what impact that all has on the tests. If you go to EFF versus...
it's the Constitutional Court decision.
Yes, the Constitutional Court, unanimous. There were two decisions. One was Khampepe, which was
everybody
unanimous.
Concurred.
Yes.
Each judge concurred in both.
Both of the, yes, yeah. both unanimous, yes.
Yeah.
So if you go start at 108, my lord. It says, when the High Court determined the first part of the application, it was exercising powers conferred on it by Section 172(1) of the Constitution. On the authority of Our School Ermelo, the power to make a just and equitable order does not depend on first declaring law or conduct invalid. Considerations of justice and equity permeate every order made in a constitutional matter. I say a lot more about this later. In other words, to paraphrase, the only test on a 172(1) basis is considerations of justice and equity. Is it just and equitable? And then he says at 109 chapter J, therefore the High Court erred and concluded that, which is what this court is being asked to do, that Part A of the application before this court does not constitute constitutional litigation. Okay, that's a different point. The fact that the interim interdict may be granted in non-constitutional litigation does not mean that if sought in constitutional litigation like review, it is not part of that litigation. Here's the important part. Earlier, and relying on the decision of this court in Outer, that's Mr. Mainecha's point, the High Court held that the purpose of the interdict was to protect rights yet to be determined. Then jump, my lord, to 110. The outer standard which the High Court embraced and applied is applicable to constitutional matters, and so on, what we all know. Then at 113, I think is the gist. Yeah. Says, therefore, even if it could be said that there were prospects of success against the grant of the interdict, the applicants for leave would still be faced with the question of whether there was prospects against suspension. In other words, whether the suspension of that, or I think it was a remedial action of the public protector or whatever in that matter. And here he says, requirements for suspension differ from those needed for an interim interdict. The outer standard does not apply to suspension. So even though we all know that a so-called suspension in effect is a prohibition, so it's an interdict by another name. Even though it would have the same effect, but to that relief, the outer test does not apply. And that is for a reason. So Mr. Mainecha's thesis that it matters not whether you are in the land of 172(1)B or operational structural interdict or whatever, it all comes back to outer, is wrong in law, according to the Constitutional Court. So your Lordship's mapping of the two pathways is therefore correct, which is to say simple. One pathway is declarator, 172(1)B or Section 38, gone. But if we are wrong on that, then the second pathway is, in fact, there are three pathways. The second pathway is Mr. Ngalona's approach. Common law, normal, outer, and all that, boom, gone. But the third pathway is your Lordship fashioning a relief such as a suspension, where your Lordship will not be then bound by the outer test and all that, but by the interests of justice and justice and equitability and weighing these. Where Mr. Mainecha might be right is that even in that exercise, obviously one has to look broadly because it is by its nature discretionary. But that's not the same thing as saying the outer test, you just plaster it around like that.
Yeah.
Thank you, my Lord. I'm just checking if there's anything else, my Lord.
Yes.
Okay, yes. My Lord, I won't belabor this point. I implore your Lordship to just do a simple exercise and take our letter to the JSC on Monday, and then take the letter that the JSC wrote to us on Tuesday. And I must commend the JSC for they actioned our letter. Within that evening, I'm told there was already a virtual meeting or whatever. And the Lordship must simply say this. You'll see in our letter, we even apologize. We say we apologize for the length of this letter because we wanted to avoid this kind of debate. That's why we went to town to say, the section 18 might happen, might not happen. Please, this is not about the quorum, it's about composition and so on and so on. Because we didn't want, when people are sitting in that meeting, to be debating those trivialities. And wrote a very detailed letter. So if your lordship takes that letter and see the spirit in which it was written, which is to say, let's avoid litigation, let's have a draw kind of situation where there's a truce. And then you see the response to that letter, which actually makes it clear that they did not read the letter, or if they read it, they didn't read it properly. Because then they come and do exactly what we said they mustn't do. They conflate quorum with composition, and then they invoke section 18 in vain, which is what we had gone to town to make sure that they don't do. And we even sent, once the leave to appeal was out, we immediately sent it in the evening, I think an hour before their meeting. All this was for one purpose, so that they don't get waylaid into the wrong section 18 wild goose chase, or the wrong section 178 wild goose chase. But that's exactly what the JSC did, with the greatest respect, and ignored the via media that we were trying to say, and went gung-ho, no, we're bound, and no, it's 18.2, and no, he was not removed. And my lord, this is the last submission on the SCA. Surely Mr. Bishop cannot be serious that this court is bound by the full court interpretation of the SCA judgment. Because there's one of two things. Stare decisis doesn't work like that. If as Mr. Bishop, and I hope I'm not targeting the wrong person, if as my learned friend says, that all that the Lidwaba DJP and Sutherland DJP judgment did was to confirm the SCA judgments. That's scenario one. Then, of course, your lordship is still bound by the SCA judgments more, because they have a binding effect. Obviously, two SCA judgments versus a full court judgment, the binding effect will lie with the two SCA judgments. If, on the other hand, that's scenario two, the High Court judgment contradicted the SCA judgment, then again, your lordship is still bound by the SCA judgments until they are overturned, until there's another judgment that says the full court was right. So, whichever way you look at it, the judgments that are binding upon your lordship are the two SCA judgments, and both of them say the same thing. They say the following: the general rule, and to his credit, Mr. Maneche accepted this. The general rule is that if the JSC is not sitting en banc, then it's invalid. That's the bottom line. However, it says, those courts say, and that's the thing about the justified exclusion. Yeah. Of course, as all legal rules have, they always have an exception. Of course, if there's a justified reason, then that general rule may be attenuated. We all accept that. But let's not confuse the court. The general rule is very, very simple. It comes from Ski Road. If there is a statutory board of directors, school board or whatever it is, which is prescribed to sit as a whole, then if it's not sitting as a whole, that decision is invalid. So the question before your lordship is a narrow one, going to your lordship's straight line example. It's very simple. Is there a valid justification for the non-postponement decision of the JSC? There either is or there isn't. If, and nothing has been said to convince anyone in this court, least of all your lordship, that there is. And to do that, your lordship will have to go back to the exercise I asked your lordship to do. Take the two letters and your Lordship will see that none of those things listed there lends itself as a valid justification for the non-postponement decision. Least of all, the idea that because you are bound by a decision, therefore it means you must not postpone. And if we're correct in that alone, then your Lordship must grant the declarator, and the rest I'll be repeating myself. So those are our submissions, my Lord.
Yes.
As far as costs are concerned, our respectful submission, there was some contrivance about the fact that these people are working in Parliament and therefore they are public. I don't think that was seriously meant. So apart from the issue of the freedom of expression or no freedom of expression, which your Lordship is correct, and let me speak for myself. I agree with your Lordship. One cannot condone those remarks. But whether or whoever issued that statement or did not issue it or was part of it or knew about it and so on, that might be clarified in the appropriate inquiry, as your Lordship said, not before your Lordship. So apart from that, my Lord, if there ever was a deserving case, it is this one, my Lord. To actually say somebody whose fundamental rights in terms of Section 19 are being limited, infringed, violated, whichever word you like, must be punished for coming to court to say, court, please rescue me. I'm being closed off in sentence somewhere, and that act infringes MK's rights, and it also infringes Dr. Klope's rights. Rightly or wrongly, win or lose. To say that, to actually assert that is a punishable offense, my Lord, is really gilding the lily and taking things too far. So, my Lord, with the greatest respect, your Lordship must, with the greatest respect, I say this with the greatest respect, find that the legal effect of the Cape Town order is to reduce the constitutionally ordained 50% threshold to 40%. And by doing that, ipso facto, what was said in paragraph 35 of Bar Council, the constitutional design is disturbed, and so on. And a court order cannot be allowed to do that, because it is the Constitution that is supreme, not the court. We respect the court can give orders and so on, but no court can give an order that breaches the Constitution. If it does, obviously it's not doing it advertently. And if it does, then the court, this court now, it is the duty of this court to say that the legal effect of this, intended or not intended and so on, but the legal effect of this is to disturb the constitutional design. And I, as the court, will not allow it. And then I'll find some structural way which balances all the rights, what all my learned friends have said. And that's all we're asking your Lordship to do, so that on Monday we don't have an illegality continuing in our town. Thank you.
May I ask for your leave just for half a minute?
No
just
objection.
to deal with an issue that we could not have anticipated, which is the instructions
Yes,
conveyed
half a
from the
minute.
bar that there will be a challenge to the 5. The implications of that is that the promises of our learned friends that this, if there's going to be a postponement, is a 2 months or 3 months postponement, is really pie in the sky given all these challenges that are coming.
Yeah.
That's all we needed to draw
Yes,
that to
thank
your
you.
Lordship's attention. As the court pleases.
Sorry, my Lord. I don't object, but I just have to say one sentence. That's not true. All my learned friends have missed everything. The reason we say, my Lord, we give you 3 options for the, let's call it Part B. My learned friends have all missed this. We say either you must await the application for leave to appeal, and we concede that it's not going to take 2 weeks. Might take 2 months, might take 3. Mr. Manager might be right, it might take 100 years. Okay? And then we say the second one is that Part B of the Western Cape Court must be entertained. Take 1,000 years, it might. But we say, or Part BB, whichever happens first. And we've demonstrated to your Lordship that Part BB, which is really the analysis of a letter, can never take more than. That's all we're saying. So accept Mr. Manager's 20,000 years for the thing. But the way we formulated it was to make exactly sure that we ameliorate any harm that might eventuate as a by taking the lowest threshold, which is Part BB. Assume the courts won't give us expedited hearing. Assume we'll bring 1,000 counter applications, whatever you. But surely your Lordship knows that any JP will be able to case manage this thing such that it can be disposed of quickly. We're not making. So I'm not putting. I don't want one day to say you said 3 months or whatever. I'm simply saying this is not this whole thing that the sky is going to fall is 100 years and so on. It's something that can be limited, but in the best case scenario for them, it can only be pegged to Part BB, which, by the way, your Lordship said might even be rendered academic.
Yes.
And I agree with them.
Thank you.
As God pleases.
Yes. I propose to reserve judgment for a short while. I anticipate being able to give judgment during the course of tomorrow. I will circulate the judgment by email. My registrar has a list of all interested parties. I dare say that if members of the press present wish to receive the judgment more or less as it's handed down, if they send my registrar an email, he will accommodate you on his list. Mr. Mpofu, Mr. Mayaniche, that is sufficient to allow your clients to organise themselves in light of whatever I decide, is it?
Yes.
A judgment during the course of tomorrow.
Yes, I think it should, under the circumstances that.
Yes. So if, in other words, I say the JSC meeting can go ahead, I won't make that impossible by taking until tomorrow afternoon to say so.
Yes.
That's,
because of travel arrangements.
Yes.
And all that.
Yes. So if I decide the JSC can go ahead, to do so by tomorrow afternoon wouldn't create any problems.
I would assume, but I think my client would appreciate that that's most expedited.
Yes.
Response from the judicial.
Yes. I'm not going to give an order with reasons to follow.
Yes.
I'm not going to extemporize.
Yes.
And the fastest I can move in a case like this is just under 24 hours.
We would accept that.
Yes.
My Lord, similarly, my Lord, we accept that. In fact, just to give your Lordship the assurance, one of our options was to set the special time for Saturday, but we wanted to avoid exactly that.
Yes.
So the reason why it was done on Friday was so that anybody can make whatever arrangements my clients might want to make on either eventuality.
Yes.
We are in the same boat. We don't expect your Lordship to do miracles.
And presumably no difficulty from full or the DA's perspective.
None, my Lord. None, my Lord.
Very well. Judgment is reserved for a short time. Thank you all for your assistance. Thank you all for more or less keeping to time. The court will adjourn.
And that's it.